Mention item number 12 for adjournment, Your Lordship. Kindly may the matter be taken next week, Your Lordship. After 1 week, Your Lordship. 12.
Have you informed the other side?
My Lord, yes, my Lord. I
Yeah.
called him up yesterday, but he didn't receive my call, my Lord. I'll try him again also.
No, you have to first inform, then you have to mention.
My Lord,
Otherwise, you wait for your turn. We will adjourn it, but wait for your turn. No mentioning without informing the other side.
my Lord. My Lord, on last occasion, they have mentioned the matter, I guess.
No,
And they
forget
didn't
about
inform me,
last
my Lord. I
occasion.
am the petitioner.
You wait for your turn.
Obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 25, Your Lordship. In this matter, Senior Counsel Mr. B. Datta is appearing. He hails from Tinsukia. Due to some personal difficulty, he could not appear today. So can it be on 5th of September, Your Lordship?
Heard Mr.
J. Das.
J. Das, learned counsel for the appellant, who submits that due to personal difficulty of the conducting counsel, Mr. Bhaskar Datta, an adjournment is prayed for today. The prayer is allowed. Let this matter be listed on 5th of September.
Interim to continue.
Interim shall continue till next.
May it please, Your Lordship. Prayer for listing of a CRP IO, my Lord.
Listing you have to mention before senior court.
Urgency is there, my Lord.
No one senior
This
court.
bench is also taking up CRP IO.
No, when two benches are taking up same roster, you have to mention before the
Why not?
senior.
Highly obliged.
May it please your Lordship. Lordship, I beg to mention item number 21. Lordship, kindly fix this matter after 2 weeks, Lordship. Lordship, English Council Mr. Y.S. Mandan is having some medical difficulties.
Heard Mr.
A. Sharma.
A. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground of medical urgency of the conducting counsel, Mr. Y.S. Manna. Considering the ground the mentioned prayer is allowed, let this matter be listed after 2 weeks on a date to be fixed by registrar.
Bless you.
May it raise your Lordship. Lordship, in regard to item number 16, Lordship, may I pray for some indulgence, Lordship? Can the matter be taken up at 2, Lordship? There is some personal difficulty in the first step, Lordship. At 2. I've
Have you
informed. Yes.
mentioned the other
Yes.
side?
Yes. I have informed,
Okay.
overformed.
Okay.
Deeply obliged.
May you please, Your Lordship, I beg to mention item number 43. Lordship, here the opposite party number 1 has passed away and we have to file a substitution petition, Lordship. Lordship, 2 weeks time will be granted to find an appropriate application.
Who passed away?
Opposite party number 1, respondent 1,
Heard Mr.
G. Kaushik.
G. Kaushik, learned counsel for the appellant, who submits that in this case, in this appeal, the respondent number 1 has passed away, and he prays for some time for taking appropriate steps for substituting the legal representatives of the deceased respondent number 1. The prayer is allowed. Let this matter be listed after 2 weeks.
Obliged.
May it please your Lordship. Lordship, 483 application. LCR may be called for Lordship.
Heard Miss N. Sultana, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. Perusal of the scan copy of the case record of NDPS case number
183/22.
180/22 would be required for considering the instant bail application. Hence, call for the scan copy. The registry to take steps for requisitioning the aforesaid scan copy. Let this matter be listed again
Lordship, a similar matter is listed on 19th of this month.
Oh.
Lordship may take the matters.
on 19th of August.
Bless.
Highly obliged.
Lordship, this is a transfer petition, Lordship. wife has filed transfer of the suit of restitution of conjugal rights from North Salmara to Dorong, Lordship. She is residing presently at Dorong along with her father, and she has 3 minor children, illiterate lady, and a case for maintenance is also pending
Where
at Dorong,
the
in which the
opposite
husband
party,
thinks but
bridge was stolen.
Lordship,
The bridge was
80%
stolen.
was stolen, my lord, by some ANPL construction, my lord.
You have the bail order of the co-accused.
Because I am, no, my lord, my name is not here, my lord, but I was working there, my lord. I am the local person there in the ANPL as a labor. That's why, my lord, they have, my lord, police
Mhm.
harassing me, how much you know, what is your information, page 4, paragraph 4, my lord.
1719. 1719. Print out the problem. Yes.
Page 4, paragraph 4, I have stated that. I was working, actually, I am driver, but I was
Now,
working.
why are you apprehending your
I am
arrest?
apprehending because I have stated in paragraph 4, my lord, that he is a labor, my lord, working in the ANPL construction, and he was a local person of that particular locality. The police come in searching him with a view to arrest him, so that he may be harassed in the name of inquiry and investigation. He will cooperate the investigation, my lord, he will appear, my lord, as in the court, but his custodial detention is not, it is only prayer, my lord. Otherwise, it is a ANPL company, is a
Yes, Mr. Boscho.
my lord,
it is
city is required, your lordship.
Citizen. Third, Mr. H. Das, learned counsel for the petitioner. Also, heard Mr. K. Boscho, learned additional public prosecutor. This application under section 482 of BNSS, 2023 has been filed by the petitioner Sanidul Ali, who is apprehending his arrest in connection with Krishna PS case number 38/2024 under section 420/468/379/34 of the Indian Penal Code. The gist of accusation, Code Para 3 from bail application 1719. Yate aase record hote. Code Para 4. Code Para 5. Mr. H. Das, learned counsel for the applicant, learned counsel for the petitioner has submitted that the petitioner is a driver
yes,
presently employed in ANPL
PL. Azra,
construction
Construction.
company, and he is in no way involved in the offense alleged in the FIR. Alleged in the FIR. Stop. And he shall cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that considering the nature of the offense involved, the perusal of the case diary would be necessary. Hence, call for the case diary. It appears in the instant case, one accused, namely Jahidul Islam, who was earlier arrested, has already been granted bail by this court. And while granting bail to the said accused, in the bail order, an observation has been made by this court that after perusal of the case diary, it appears that the investigation has fairly progressed. Hence, till arrival of the case diary, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary. Hence, the petitioner Sanidul Islam is directed to appear before the investigating officer of Krishna PS case number 38/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so, within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Let this case be listed again on
5th of September.
5th of September for this day.
May it pleases your lordship, here I am representing as legal aid counsel here, lordship. Here, your lordship, impugn order dated 5/7/2024 has been passed by FC civil case number 612 that has been passed by learned district judge Nodam,
Page,
Which-
page number?
which I have annexed it, your lordship.
What is the order? What?
Your
what
lordship,
is-
here, your lordship, a written statement has been closed against a respondent. Here,
Close.
closed, your lordship, that I had annexed it, your lordship, 20 to 26, page 20 onwards. I would like to read, your lordship. 5/7/2024, case record is up before me today,
No, why it was closed? You failed to.
page 21. Page 21. Here, your lordship, since the Honorable Guwahati High Court has specified a particular date for filing written statement.
You approached High Court earlier also.
Yes, your lordship, for transfer petition that against the FC civil case number 612/22. That also I have annexed it, your lordship,
Then
On-
on your prayer, the case was transferred.
transferred also.
And
Your
in
lordship,
that
on dated
order,
13/5/2024, in that order, your lordship, it has
specific date
specifically
was
written.
mentioned.
Yes, your lordship, it was
Then-
mentioned that no further time will be
Then
granted.
why you
for-
failed?
Your lordship, as per your lordship records, I have communicated them, your lordship, but due to your lordship sudden ill, your lordship, because that
Due
petitioner
to what? Ailment.
sudden ailment, disease of she fallen sick with that the
Oh.
petitioner daughter, your lordship. I have mentioned it, your lordship, in page 5, paragraph 5. That the petitioner present on dated 1/7/2024 as a respondent by her learned counsel but unable to submit her written statement. Her represented counsel has filed a petition, white petition number 598/2024 on dated 1/7/2024, seeking some extension time for preparing written statement. As learned court below passed the necessary order 5/4/2024, where it is mentioned that the liberty was given to the petitioner, the respondent, to file her written statement before this court 1/7/2024. It appears from the records, instead of filing written statement, the learned counsel representing the petitioner, that is the respondent, has filed the petition white 598/2024 dated 1/7/2024, praying for grant some extension for filing written
Okay,
statement.
whether this is a divorce.
And your lordship,
right.
I mentioned the reasons behind
What
that,
is
your
the
lordship.
case? What is the case
Restitution,
of conjugal right?
yes. Your
Whether your husband has appeared.
On that day, that husband has been appeared through represented counsel, but not physically he is there, your lordship.
Physical appearance is not necessary, whether he is contesting or not.
Your lordship,
It's
he
not.
is contesting, your lordship.
Then we are issuing notice.
Just your lordship, on the next date, evidence for the petitioner's side is fixed on dated 17/8/2024, that is on page 21. Last two line. And your lordship, taking to page 6 and paragraph 6 of my petition, therein your lordship, petitioner has a minor daughter whose health condition was not stable from the
Okay,
past March month
Heard
2022.
Heard Miss P. Das, learned legal aid counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, Srimati Rita Basford, impugning the order dated 5/7/2024, passed in FC within bracket civil case number 612/2022 by the Court of Learned District Judge Nagaon. Where it has been transferred now?
Your lordship, Nagaon,
Nagaon,
Nagaon.
District Judge Nagaon,
District Judge Nagaon.
whereby the further time for filing written statement by the present petitioner in FC civil case number 612/2020 has been rejected. Issue notice to the respondent. The petitioner shall take steps for issuance of
Kind
notice,
stay may granted, your lordship.
issuance of notice to the respondent by registered post with ID as well as by usual mode within 3 days from the date of this order. What is the next date fix?
It is 17/8.
3 days from the date of this order. The notice is returnable on 13th of September 2024. Stop. Considering the fact that the next date of the FC civil case number 612/2022 has been fixed by the trial court on which date?
17/8/2024.
17th of
upcoming
8.
Saturday.
And also considering the averments made in the instant application as well as submission of the learned counsel for the petitioner, the further proceeding of FC civil case number 612/2022 shall remain stayed till next returnable date, list accordingly.
Deeply obliged.
This is an application, revision application against the impugned order, lordship. Page impugned order, page 143, lordship. So 143 is the impugned order.
26.
Lordship, that is the execution petition. I have already filed the execution petition that has been dismissed. That against that order, I filed this petition. Because execution proceeding is going on, simultaneously second appeal is pending, Lordship. So order is not become final. This order reflects here on this order 27/24 impugned order, that second appeal is pending, notice has been issued. So where I am in the.
But in the RSA, no stay has been granted.
That is, lordship, if it stays not granted, it is futile, lordship, futile exercise. Because when second appeal, lordship,
No,
kindly see the
no,
order.
my query is whether in the second appeal, any stay was
No,
granted, no
second appeal-
stay,
Second appeal notice has been issued now because delay is there.
without,
Delay is there, that's why.
without staying the execution.
No, the lordship, second appeal, notice has been issued because on the condonation of delay. That is reflected in notice. I have received a notice also.
You have filed against,
No, what is the case?
who filed the second appeal?
Lordship, I am stating the facts, lordship.
Yes,
That the one, Lazima Begum had filed first suit. Title suit number.
title suit for,
Title suit for defaulter and as a tenant injectment. So
Okay.
title suit 208. Right. page 15 is the plaintiff. Lordship kindly turn to the page 15.
Suit for eviction.
Suit for eviction.
Eviction
Eviction.
on the ground of defaulter.
Defaulter. So that suit,
You were the,
I am the tenant.
you were the tenant.
Tenant. So this suit,
Suit was decreed.
it was dismissed.
Suit was
Suit was
dismissed.
dismissed.
Okay.
So against this dismissal order, she filed an
Appeal.
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 In appellate court, reversed the judgment.
Okay.
That is there. Reverse the judgment on contest. That is title so dismiss on contest, page 46. Lordship. Then title appeal 7316 filed by the heir of Nazima Begum. Because title appeal that has been filed by the successor the legal heir of the Nazima Begum. So judgment dated title appeal 7316
Nazima Begum was the plaintiff in the,
in the original suit.
and present respondents are the heirs of the Nazima Begum.
Yes, Lordship.
Present respondent in this.
Present respondent.
Okay.
So appeal allowed and reverse the judgment. That is page annexure 4, page 49 to 69. Page 49.
Okay. Thereafter,
Thereafter, Lordship, like, here, Lordship, kindly see the page 50. There, in order, there the last line. The respondent, though appeared through its learned engaged counsel, thereafter did not appear the appeal. Because during this period, the COVID was there. So this is the judgment. It is recorded, says respondent, though appeared through the learned counsel, thereafter did not appear in the appeal. So appeal allowed and reversed the judgment. Thereafter, Lordship, CRP 133, the defendant Sirajul Islam filed this. This has been dismissed on contest.
CRP against this appellate court's order.
Or yes, Lordship. That is dismissed, Lordship. So another suit filed by the sisters of this.
No,
this-
the CRP was filed by you.
Yes, myself. So that has been dismissed.
Okay.
So the other suit that is filed by the sisters and the co-sharers of the, because their allegation is that a power of attorney as well as sale deed is forced. That is already there, that title suit number 11 of 2008. That is another suit. Lordship. So against
Another
that suit,
suit in respect of some other property.
no, same property. Same property.
What was the,
That
Right.
their allegation that I am being a brother, I have already forgery the power of attorney and I have sold out their share of the property. This is the allegation. So this is title suit number 11 of 2008. Annexure 6, page 84 to 100. That is the plaint.
no,
Then
this I have not understood. Your suit was a
No,
eviction suit where you
Yes.
were a tenant.
yes,
Suit was decreed against you.
no.
Suit
favor-
was dismissed. Suit
Suit was
was
dismissed.
dismissed. Then an appeal was
Against that-
preferred.
Against that, they preferred the appeal.
Appeal, in the appeal,
allowed. Appeal allowed.
the
Judgment reserved, reverse.
judgment was reserved,
Reverse.
reversed, and the
And that is.
trial court's,
Got it?
trial court's judgment was reversed.
Reverse.
And the appeal was decreed.
Got it?
The
On the basis of judgment of the appeal, the execution proceeding starts.
they filed an execution proceeding.
Execution case, that execution starts, and I am against now, this is the petition.
Now,
against-
who preferred the regular second appeal?
My legal area and others, where I am a party, I am respondent. I am getting received notice also from the court. Kindly see the order and notice.
You have not preferred the second appeal.
No, I have not. I prefer this revision petition which have been dismissed. And here they preferred this appeal, second appeal, which is pending, and I am a party in the respondent,
Second appeal in respect of which,
same property. Same property.
some other case.
No, same property and against this the other party. So annexure 9, page 1 to 23 is notice received from the honorable court. So this is pending. So when this is pending, how the execution, if execution proceedings goes on, then this futile exercise entire has been frustrated.
No, that plea you have to take before the second appellate court.
But the second appeal of notice, I have received the notice only because it is delay, content of delay petition is there. This is the notice.
delay may not be condoned.
That is, I do not know, I am a party here, but it. They
But you
prefer-
have not preferred second appeal.
No, I have not preferred. second.
Then what right you have to
No,
oppose
as
the?
because I am a party there. That's why. I am a party, it should be noticed, because my apprehension is, suppose original court judgment is reversed like this, so second appeal, that may be dismissed. So in that case, then my original degree will.
Where is the plaint? Show me the original plaint.
Which case, Lordship?
Your case, which was dismissed.
That is annexure one,
The suit which was filed by Nazima Begum.
Lazima, annexure 1, page 15.
Page
15.
Lazima and Sirazul.
Yes,
There only
Master.
you were the defendant.
yes, I'm dependent here.
Then how second appeal is filed by another?
They said, I have not preferred the second appeal. The Lazima, because now,
No,
now I am a
no, I
party.
have not understood. In the
Difficult
title
to
suit,
understand me also, because Lazima Begum filed the suit. So I am a party there. So suit, this is dismissed. So,
no, let me put queries.
Lord,
Lazima Begum filed the title suit number 200
yes,
for your eviction.
eviction,
You
yes,
were
as a defaulter,
you were her tenant.
yes,
The ground was the ground
That
of
is the ground.
defaulter.
but
No,
ultimately,
Mr. Rahman,
Lord,
listen to me
Lord,
because I have to understand.
no,
You know your case.
no, I also find difficulty,
Lazima filed the suit
yes, title suit number.
for
200.
your eviction
Yes,
from the suit property on the ground of defaulter.
Yeah.
And the suit was dismissed.
let me correct it. Lazima Begum filed the first suit as a defaulter, but it was amended. That's why kindly go through page 21 prayer, Lordship. Lazima Begum's prayer. Amending prayer. Decree right title. Page 21. That is the prayer of Lazima Begum.
She decree for right title and interest as
Yes.
well as for ejectment. It was dismissed. Against this dismissal,
Appeal.
she
appeal
preferred an appeal.
So title
The-
appeal
Appeal
Seven-
is
73-106 filed by the heir of the Lazima Begum.
in the meanwhile, Lazima expired.
Lazima expired in the meantime.
The title appeal, where is the order?
Annexure 4, page 49 to 69.
49. In that title appeal before civil judge senior division,
Yes. Page
the
49 to
appeal
69.
was allowed.
Yes,
Appeal was allowed
allowed.
and a decree was passed against you
Reverse.
for eviction.
No. It is reversed, Lordship. The judgment was reversed because
No judgment, that is appeal was allowed
allowed.
and it was directed that you will be evicted from the
evicted
suit
from the
property.
suit claim.
Against that appeal, you filed a civil revision
Civil
petition.
revision.
Where is that?
Civil division CRP 133,
Page?
that judgment is page 75 to 83 is dismissed.
Against that first appellate court's order, you
80
filed,
75 to 83, it is dismissed.
the appeal was dismissed.
Dis-
Now, against this dismissal,
Yes.
is there any second appeal?
No,
No.
I have not filed a second appeal.
Then
I-
your
I-
case
no,
ends.
No, I have mentioned here, we are preparing for go for SLP on this case. Here I have mentioned.
No,
Let me-
now what is your case?
Lordship,
What is your case in?
Case is that-
Against,
Lordship, that against this orders, 133.
let me put one more query. Let me put one more
Lord.
query. After your CRP was dismissed,
Dismissed.
the heirs of Nazima filed an execution case.
No, that is the execution, the other case, another title suit is there, Lordship.
No, let us forget about the another
Another
title
case.
suit. For your eviction, whether any execution case was filed,
Yes, that is the case.
that is execution case number.
That is the impugn order, I have mentioned that is the execution case.
Where is the impugn order?
The title execution 24 of 22,
Page number
page number 143.
143.
That is the order impugn here.
One forty-three,
Page 143.
the heirs of Nazima filed an execution case, title execution 24.
24.
There you filed a application that now you make me understand what happened.
Yes, sir. So my application has been dismissed.
Application for stay.
No, application for stay has been dismissed.
No, what, on what ground you prayed for stay?
No, no, here, because I like to prepare an appeal on the honorable ex report because.
You
it is
have
there.
not yet preferred an appeal.
No, not yet. Decided.
So that may not be a ground for allowing the,
Lordship, the second appeal is pending also.
but how second appeal is
Second
related
appeal,
to this case?
I am a party in the second appeal.
But second appeal is not related to this case.
Yes, it is case. Second appeal, this case, Lordship.
How?
Because here, title suit 1/11/2008, Lordship kindly see the ex parte order dismissal, page 101 to 133 judgment, 101 to 133,
No, I have,
112 page.
you have, there is no second appeal in the,
In my case, it is not second.
there is no
appeal.
second appeal.
No, in my case, I did not.
Then how this second appeal is related to this case?
No, because second appeal, I am a party, and because they made me party, I am given.
No, you may be a
department
party.
notice.
Second appeal is in relation to what matter? In this, in the, say, you are in
Same
possession
sort
of what, a room or a premise?
Lordship.
What is the suit property in the,
Suit property, land and house.
in your case?
Yes.
In your case?
Land and entire house.
That land and house is also a subject matter of some
Subject matter of
other case.
Yes. So only thing, because this, whether the power of attorney is a regular power of attorney, not that is a disputed here, second appeal. Then power of attorney, allegation is power of attorney given to the follow, because my
But you
property.
cannot take that plea in this case, in eviction case, where that is
But,
subject matter of a different case.
But in this case, Lordship, that is up to your Lordship to decide, because the execution case is already going on simultaneously. I like to prepare an appeal also. So that is Lordship, and my apprehension is Lordship, if it goes on, execution is continuing, then nature of the character, everything will be changed.
Now you tell me about the second appeals case. In the second
Second-
case where the second appeal has been preferred.
I received a notice, page not
What
one,
was the original suit?
in this
Who-
case.
Not in this case. Your case I have understood. In the case where second appeal has been preferred.
No,
That is a
second,
different case.
that I don't know, because I have not yet received, only received notice where I am a party. I have annexed the 123, annexation 9. I have
Who
annexed,
filed this title suit number 11?
they have prepared this title appeal number 9 of 16. Page 124, that is the order.
What is this? This is condonation of delay application.
Yes. Then 124.
This
that is-
case is in between different parties.
No, I am party.
You are one of the party, but
But other party are there. But I am a.
Nazima's heirs are not the
I am
party.
respondent number 1.
Nazima's heirs are not the parties.
So Lazima's, their party is there. Party is there. Nurun Nahar. Nurun Nahar is party. Item 4.
Mhm. Who filed this application before the executing court on 2nd of December?
What's it?
Who filed this application before the executing court,
Very good.
on which the impugn order has been,
That is,
on the basis of whose application impugn order was passed? Who was the petitioner?
that's- yes, successor of the Lazima Begum. Not a person, but it-
She is a stranger to this case. The eviction suit
but
that the person who filed the petition, you have not filed that petition.
No, I have, because again, this is against me, Lordship. Who is very complicated, Lordship. Because what happened.
Then you clarify
No, what happened was, Lordship, actually, actual fact is that the advocate who was interested in this case, he is suffering from fever, then ultimately pandemic comes, then ultimately he died. So that is why files and everything were lying with the advocate's chamber. So no connection, that is why delay is there. So these things are there, Lordship. So considering all this, for the default lawyer, party should not suffer. That is my legal point, Lordship. That at least at this stage, they let second appeal may be decided.
No,
Then-
second appeal has no relationship,
No, not yet, because only notice, delay notice. has
and
been-
it has, how it is related to the present case, that you have to
Because,
make me
because
understand.
I have made a party, that is why. I received the notice from the Honorable Court. This is the order I have respected. I have submitted the order also.
Now, what is this title suit 11/2008?
11 of, that is filed by the sister of Sirazul Islam, challenging the power of attorney. Annexure 6, page 84.
Power of attorney in respect of, in whose,
In respect of this, Sirazul Islam executed a power of attorney, which they allege that it is a false power of attorney.
now how this power of attorney is related to this case?
Because the power, on the strength of the power of attorney, the entire property has been sold out. So they have
Sold out
challenged
to
the,
whom?
they have challenged the power of attorney as well as sold it also. In this suit, this title suit 11 of 2008. 84 to 100, like the plain is there. 84 to 100.
No, you have to answer my query.
What?
How the regular second appeal, in which which has been filed by Firoza Begum is connected with this case? This is first query.
That is related why because the same property. Both the suits are in same property. Because first is Lazima Begum DS filed a suit that for default as a defaulter.
That I have understood.
That has been dismissed. But sister of my Sirajul Islam, they filed this because Sirajul Islam executed a power of attorney, which land belongs to their mothers. So without partition, how he can execute?
But
the-
Sirajul Islam is the tenant.
Actually, he sold out the property on the strength of a power of attorney, which they have challenged now.
No, I have not
In
understood.
another suit. No,
In
Sirajul
respect-
Islam
in-
initially he was not a tenant.
Huh.
It is his house which was purchased by the Lazima Begum. Lazima Begum allowed her, as per the complaint, I have,
To remain there as tenant.
yes,
Okay.
that until and unless his possession is handover and he was remaining as a tenant, that is the allegation. That there was a tenancy agreement also. I do not know whether from the record I am saying that there is an agreement for tenancy agreement. So she filed the ejectment suit first. That is the sort.
Now your sister has
Claim.
claimed that
That
the,
Sirajul Islam's
the,
property, because it is ancestor property,
the sale of property to
Is illegal.
Nazima
it is illegal.
by virtue of a power of attorney,
And the sale
is
deed
illegal.
both are illegal.
that suit has been dismissed.
Yes,
Your sister's suit was also dismissed.
dismiss. They
Then
dismiss,
she filed an appeal.
appeal.
That was also dismissed.
So
Then you filed a
second, appeal.
second appeal, which is delayed,
Yes,
and the condonation of delay application is pending.
pending.
Now, on what ground the execution should be stayed?
All of it is lordship to decide because only because one second appeal is pending. Then judgment not become final.
What should I do?
That's it to decide because my submission I have completed now because
I don't see a case here.
at least at this stage, execution may be stayed till the disposal of this case. That is,
No, I'm disposing it now itself
that is not to be decided.
because you don't have a case. That is my,
But second appeal I am fine. I have already pointed out in the notice as well as the order. But legal point attorney and the sale deed, because it is the allegation only for which these cases are pending. And lot of know the recent judgment of the Supreme Court, there are only the strength of the power of attorney, land cannot be transferred.
where is petition number 1061?
1, 2.
One zero six one. In the impugn order, there is a mention about one application, 1061.
137. 137. Here 137 page.
Who filed this application?
Firoza Begum and others.
But
Decree
you,
holder.
you have not filed.
No.
Then
Against me, it's fine. I am Sirajul Islam.
no, but it cannot be against you because who is the decree holder?
That Firoza Begum and others decree holders. Lazima's,
No, not Firoza Begum.
that is also not
This,
correct,
this
Lordship, because
petition has been filed by one Noor Nahar Begum.
no,
Who is Noor Nahar?
Sister-in,
She is the
sister-in-law,
sister-in-law of
not Sirazul Islam. Lazima, sorry.
Third, Mr. H. Rahman, learned senior counsel, assisted by Mr. What is your name?
BJ Das.
P.J. Das, learned counsel for the applicant. This application under Article 227 of the Constitution of India has been filed by the petitioner Sirazul Islam, impugning the order dated 2/7/2024 passed by the executing court, that is the Court of Learned Civil Judge, Junior Division number 2, in title execution case number 24/2022, whereby the application filed by one Musammat Noor Nahar Begum, praying for stay of the execution proceeding, was dismissed by the executing court. Stop. The facts relevant for consideration of the instant. No, before that, not. Learned senior counsel for the petitioner has submitted that the predecessor in interest of the respondents in this revision petition, namely late Lazima Begum, had filed a suit for ejectment against the present petitioner, which was in respect for eviction of the present petitioner from the suit property which she had purchased from the present petitioner on the strength of a sale deed number 9414/2007 dated 27/7/2007. Stop. The said suit was contested by the present petitioner by filing a written statement. Stop. However, by the judgment and decree dated 24/5/2016, passed in title suit number 200/2008, the suit filed by the predecessor in interest of the present respondent was dismissed by the trial court. Stop. Against the said order, this judgment of the trial court, the who preferred, Lazima preferred or
Successor,
success?
Lazima died. During the time Lazima died, the successor.
Okay. The the
Legal there and certificate.
the legal representatives and successor of the original plaintiff preferred an appeal before the Court of London, Civil Judge Senior Division Number 3, Kamrup Metro. The said appeal was registered as Title Appeal Number 73/2016. So the appeal was heard in absence of the present petitioner and by judgment dated 28/4/2022, the appeal was allowed. By the judgment of the first appellate court, the judgment and decree of the trial court was reversed. Stop. After stop. Thereafter, the successor of the original plaintiffs filed the title execution case number 24/2022 for execution of the decree passed in the first appellate court in title appeal number 73/2016. Stop. Against the judgment and decree of the first appellate court in title appeal number 73/2023, the present petitioner preferred a civil revision petition before this court, which was registered as CRP number 133/2023. Stop. However, the said civil revision petition was dismissed by this court by order dated 8/5/2024. Stop. Learned senior counsel for the petitioner has submitted that the petitioner is considering to file a SLP before the Apex Court of India. Stop. In the meanwhile, another development occurred, that is the that is, who is the sibling who filed the title suit number
11 of 2018. That print 8400 to 84.
84? You are not party to that case, no?
Yes, I am party. Respondent
In
number
the
one.
meanwhile,
Respondent number one.
no, in the suit you were not party.
No, yeah, I'm party. Title suit 11.
In title suit 11,
Yes, next page, my name is there, respondent. 1, 2, 3,
Okay,
then
okay.
versus number 1, I'm Siraj.
क्या लिखा? No, they, in the meanwhile, party job. There is learned senior counsel for the petitioner has submitted that there is another development which is relevant to this case. That is, before filing of the suit, namely title suit number Title suit number 200/2008. Who is Samsul Nahar? Your sister or your sister-in-law?
Sister.
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 And who is Noor Nahar?
They're all sisters.
The sisters of the present petitioners.
Number 3 is brother.
Namely, sisters and brothers of present petitioners, namely Muhammad Samsun Nahar Begum, Muhammad Nurun Nahar Begum, and Muhammad Nazrul Islam, had filed a title suit for declaration of right title and interest and for recovery of khas possession, along with permanent injunction, as well as for cancellation of deed of power of attorney number 1400/07 dated 7/3/2007 and sale deed number 9414/2007 dated 24/7/2007 against the present petitioner and 3 other defendants. The said suit was registered as title suit number 11 of 2008. Stop.
This is ex parte dismissal. Page 1 and 2.
Title suit 11.
Yes, that is this title suit 11 of 2008. It is dismissed on ex parte.
It was dismissed.
Dismissed on ex parte. Lots of page
Oh, okay.
112, that is reflected.
By judgment dated 12/10/2015, the trial court, that is the Court of Learned Munsif number 2, dismissed the title suit number 11/2008. Stop. Against the said dismissal, the siblings of present petitioner preferred an title appeal before the Court of Learned Civil Judge, Senior Division number 2, Kamrup Metro. Stop. Said title appeal was registered as title appeal number 9/2016. Stop. However, the title appeal was also dismissed by the appellate court by its judgment dated 29/8/2019. Against the against the judgment of the title appeal passed in 9/2016, the plaintiff of the title suit number 11/2008 preferred a second appeal before this court. However, as the appeal was barred by limitation, now as the appeal has been filed after the lapse of the period of limitation prescribed for filing the said appeal, an interlocutory application was filed along with the same for condoning the delay in referring the said second appeal. Stop. The said interlocutory application has been registered as IA within bracket C 167/2024. Now, who preferred this application under Order 21, Rule 26? It is not you.
No.
Your sister.
Sister.
Okay. But you have mentioned in para 10 of your memo of appeal as that he preferred the. Thereafter, learned senior counsel for the petitioner has submitted that in the meanwhile, Musammat Noor Nahar Begum, who is the sibling of the present petitioner and who has preferred the second appeal in connection with the case filed by second appeal in connection with the judgment and decree passed in case of title appeal number 9/2016 as well as title suit number 11/2008. The last line to last line. Has filed an application under before the executing court under Order 21, Rule 26 for stay of execution till the second appeal filed by the said petitioner is decided by this court. However, by the order dated 2/7/2024, the executing court has dismissed the said prayer and the said order of dismissal has been impugned in this instant revision petition. Stop. Learned senior counsel for the petitioner has submitted that since the property in respect of the instant case, that is with instant case within bracket title suit number 200/208 2008 as well as title appeal number 73/2016. This execution is in respect of title appeal number 73/2016. Yeah, one more last line. Since the property instant case within bracket instant case, that is title execution case number 24/2022 in respect of decree passed in title appeal number 73/2016 is same as that of title suit number 11/2008 in respect of which the appeal has been preferred by the sibling of the petitioner. In the event of allowing of the appeal of the in the said case, it may have an impact in the execution of the decree passed in title appeal number 73/2016 also, and therefore he has prayed that till the disposal of the second appeal preferred by the sibling of the petitioner, namely Noor Nahar Begum is this Noor Nahar Begum, the execution of the further proceeding of title execution case number 24/2022 be stayed. Stop. Stop. I have considered the submissions made by learned counsel for the applicant, petitioner, learned senior counsel for the petitioner, and have gone through the memo, gone through the petition as well as the annexure annexed along with the petition. On perusal of the impugn order, it appears that the impugn order was passed on the basis of a petition under order 21 rule 24 of the Code of Civil Procedure. However, it is pertinent to note that said application was not filed by the present petitioner, but one Musammat Noor Nahar Begum, who the petitioner claims to be his sibling. And Musammat Noor Nahar Begum has not preferred any revision or has not preferred this instant revision petition. Therefore, apparently it appears that the petitioner does not have a locus standi to challenge the impugn order dated 2/7/2024, which was not passed on the basis of any application filed by the present petitioner. Stop. Moreover, though the subject matter of the suit filed by the siblings of the present petitioner, that is in title suit number 2008 and title suit number 11/2008 may be same to that of the present case, that is title appeal number 73/2016, however, the decree, however, as the present petitioner has preferred a civil revision petition, had also preferred a civil revision petition against the order, against the judgment passed in title appeal number 73/2016. The decree has attained a finality, and no appeal or any other case is pending before any higher forum against the said decree. Stop. Mayor, submission of the learned senior counsel for the petitioner that the petitioner is intending to file an SLP before the Supreme Court of India may in itself cannot be a ground, may in itself not be a ground for staying the execution of the title execution case number 24/2022. Moreover, on considering the reasons stated by the executing court for dismissing the application filed by Noor Nahar Begum, this court is of opinion that, considered opinion that the reasons mentioned by the executing court in the impugned order are plausible and just and does not need any interference by this court in exercise of its jurisdiction under Article 227 of the Constitution of India. Stop. For the reasons mentioned herein above, this court is of considered opinion that the present petitioner does not have any case against the impugned order dated 2/7/2024, passed in title execution number 24/2022, warranting any interference by this court. In view of above, this application is dismissed without issuing notice to the respondent side. I'm taking short.
Condonation, substitution, and abatement, setting aside abatement and substitution, Lordship. But those are kept in defective, Lordship, because we could not give the date of death of respondent number 3. So we need some time in this case, Lordship.
What is this IA?
One IA, Lordship, is delay condonation. Because, Lordship, when the notices were sent, then
Delay condonation for main appeal
no.
for
Main appeal delay is condoned. This is delay condonation for setting aside abatement and substitution, Lordship.
now what is defective?
Defective, we haven't mentioned the date of his death. Respondent number 3. We have asked the insurance company to provide the IAs are in fact there with the registry, but
No,
so Lordship, we need some time, at least 4 weeks time, Lordship. Basically,
in registry, what IA is there?
they haven't numbered, Lordship. These 3 IAs are there, Lordship.
But before me also there are 2 IAs.
Oh, the Lordship, before Lordship, 2 IAs are delay in the main appeal and stay.
1340.
Let me first
1347.
1340.
1340.
1340.
They could stay in
But Lordship,
1340.
1340, then maybe they have passed it or what, Lordship? I mean, because we have filed one petition under
This is
section
MAC. This MAC appeal is for
MSc appeal is against the judgment. Oh, 1340.
দুটাই আছে না? The one IA is there.
1650. 1650 is
1340.
1340. One I has come, Lordship.
Yes, 1340 has come. It is for stay.
Stay is in the main appeal, Lordship.
No, this interlocutory application has also been filed. Is filed for stay.
It is with the main appeal is not yet admitted.
Oh,
But just because he has died, Lordship, so we have filed these three IAs.
oh, these three ayes are not before.
No,
this.
no, because they have kept it in objection
In main appeal, who has died?
3.
Defendant number, respondent number 3.
Owner of the vehicle, Lordship, Gobindo Deka.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr.
Lordship, S. Borua.
S. Borua for
For
whom?
respondent number 1 and 2.
For respondent number 1 and 2. Learned counsel for the appellant has submitted that the appellant came to know that respondent number 3, namely Gobindo Deka, has already passed away, and they have filed, and the appellant has filed three interlocutory applications for setting aside the abatement against respondent number 3, for substitution of legal heirs of respondent number 3, as well as for condoning delay in filing the setting aside of the abatement application in respect of respondent number 3. However, learned counsel for the appellant has submitted that the said interlocutory applications are yet to be registered, as the appellant could not provide the date of death of the respondent number 3, and therefore the said interlocutory applications are
Under objection.
placed in defective category under objection. The appellant, the learned counsel for the appellant has prayed for 2 weeks,
No, Lordship. Demand law, sorry. 6 weeks. Lordship.
6 weeks time to take necessary instructions for curing the defect of the interlocutory applications filed by the appellant. The prayer is allowed. Let this matter be listed after 6 weeks.
Highly obliged, Lordship.
Oblige, my lord.
Item 11, Lordship, in this case, we are alleging fraud, Lordship, because we adduced evidence of the police constable, Lordship, who proved that in fact the injured, it is an injury case, Lordship, injured was, he got injury at 12:30. And but the learned member has rejected the evidence because the name of the father of that injured is mentioned as Mohibul Dewan in place of Mohibul Khan. But Lordship, the document exhibited by the claimant itself, in his name is also wrong. That the court has accepted, but since the name Devan is there, that has been because when he
We are issuing notice. We are admitting the appeal.
fine, Lordship.
Heard Miss R.D. Majumdar, learned counsel for the appellant. This appeal under section 173 within bracket 1 of the Motor Vehicles Act, 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 26/2017 passed by the Motor Accident Claims Tribunal, Nagaon, in MSC case number 414/2012, whereby the appellant was directed to pay the compensation amount of rupees 1,19,000 10 along with an interest of 7% per annum thereon to the claimant respondent. Stop. The appeal is admitted. Let the notices be issued to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the MSC case record of MSC case number 414/2012 be called for from the concerned tribunal. You have any interlocutory?
Yes, Lordship, that is 1650 of 18.
What is to be done? Pay 50%.
Lordship, fraud case, so we need to full stay, Lordship, if it is a fraud case.
No, you have alleged for, but let them,
But we,
you,
okay, we deposit, but
Deposit.
Lordship will not allow them to withdraw.
after hearing them.
Huh?
After hearing
No,
them
we can
that,
deposit 50%. The Lordship will not allow them, let them file a IA, then after hearing.
heard Miss R.D. Majumdar, learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company, praying for stay of execution of the judgment and award passed on 26/2017 by the Motor Accident Claims Tribunal, Nagaon in MSC case number 414/2012. The learned counsel for the applicant has submitted that the applicant has preferred the connected MSC appeal number 372 of 2018, and they have taken the ground of fraud against the claimant in the appeal. Stop. The learned counsel for the applicant has also submitted that the applicant insurance company is ready to deposit 50% of the awarded amount before this court. Considering the submissions made by learned counsel,
I am not submitting that I am depositing, Lordship may direct us to deposit.
not
Because we, since fraud, Lordship,
on a query put by this court, I have to waive notice.
Okay.
Otherwise, notice will go
Okay,
unless you give this assurance that you will deposit.
fine, Lordship.
On a query put by this court to the counsel for the learned counsel for the applicant, she submits that the insurance company is ready to deposit 50% of the awarded amount, provided it is not disbursed to the claimant without hearing the insurance company. Considering the submissions made by learned counsel for the applicant, the notice to the respondent claimant is waived, and this application, interlocutory application, is allowed by staying the execution of the impugned judgment and award dated 26/2017, passed in MSC case number 414/2012 by Motor Accident Claims Tribunal, Nagaon, till the pendency of the connected MSC appeal. During the pendency of the connected MSC appeal, subject to payment of 50% of the awarded amount by the applicant to the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. With above observation, this interlocutory application is disposed of.
Highly obliged. Lordship.
Lordship.
Yes, you are praying for an
Yes, yes,
adjournment.
Lordship. It is for next week, your Lordship.
Any submission?
Objection, my lord.
Heard, Miss, what is your name?
ST box, your Lordship.
SP?
ST box.
Your name is not
No, my name is not in the. call, sir.
SP,
ST box,
STBO,
KTH.
K, SP Buck. Learned counsel for the appellant.
Yes.
Appellant. Also heard Miss
S. Musahari.
S. Mushahari, learned counsel for respondent number 1. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel, to which the counsel for respondent raises no objection. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Date may be fixed, your Lordship.
The registry will fix the date. Otherwise, it is difficult for us to.
Oblige, your Lordship.
May it please the Lordship. Lordship, in this case, two vehicles were involved. Lordship. The deceased was traveling in a winger vehicle whose last number is 2290. Lordship. It hit the backside of a truck. Lordship, the charge sheet is against the winger. Incidentally, Lordship, as per claim petition, both the vehicles were insured with National Insurance Company. But we are concerned with the second vehicle, which is an offending vehicle. And Lordship, insurance company had laid evidence to show that this vehicle was not insured with National Insurance Company. In fact, insurance company produced the particular policy which is cited in the A. This was issued to some Bonojit Nut. And these are two different vehicles. We are given
You
the
are appealing
numbers.
for
I am appealing for respondent 1 to 4 Clements Lordship
payments.
and
We will admit the appeal.
yes Lordship, but the thing is subject to deposit of 50% because
We are denying the policy
no,
altogether.
no Lordship, both the vehicles are insured with the same insurance company and both the vehicles are insured and
But the
Lordship,
finding, Lordship, the
No, you file an objection. You may file a,
I have not yet received the appeal memo.
no,
also.
I'll issue notice.
copy of it.
I'll issue notice in IA. You have not yet filed any execution.
Yes, I have not received the appeal memo Lordship also.
So
Second,
I'll issue notice today.
issue notice and
We are not staying it today. After hearing them, we will consider whether to stay.
Lordship, then the records may not be called for, should not be called for.
No, unless records are called. How it matters.
No, we'll receive the appeal memo, then we'll be hearing Lordship, both will be
No, but
hearing.
records would be necessary for
Reports-
consider.
If reports will be then we cannot proceed with this Bakija proceeding Lordship, 174 MB Act. Lordship.
No, you can file.
No, we cannot file in the court below without report.
Lordship, I
Now-
pray for
now-
interim protection till the
now-
next date of hearing, Lordship.
Now, actually, whether you have to proceed with Bakijay
Yes,
proceeding
Lordship.
or an execution case has to
We
be
have
filed.
to proceed with the execution case because we have not received the appeal memo yet, Lordship. So after the appeal memo, let it be fixed for after 2 weeks for hearing, Lordship.
Lordship, I'll pray.
For admission, Lordship.
Since the appeal is being.
Without
appealed,
anything, let
I'll
it.
pray for a stay, Lordship, in this case, interim protection.
No, stay we will hear.
Then he should not proceed with Bakija.
No,
Yes, he'll.
Stay,
this-
Marlene
next
is
day-
proceeding by state
he
and
might file a Bak-
since it
Bakija
is a money
immediately,
decree, Lordship.
And
of
interim
course,
protection
If both of
is
you,
given, Lordship.
both of you speak, I will hear nothing.
Yes.
One by one, you have
Lordship,
to.
I'll submit it.
Yes, Mr. Goswami.
Matter is being, if the matter.
Now,
is
what I
admitted-
propose to do,
Yes,
admit the appeal,
Yes.
issue notice on your interlocutory application.
yes. Lordship.
Now, do you have anything to say? And I am calling for the records.
Till the next date, till the application harder, interim protection, I'm not asking for absolute stay.
No, he has
Just
not yet
correct
filed,
Pending Baki,
he has not yet filed any Bakijay.
but he intends to file a Bakija application. The protection till the next day, till the petition is heard. If there is no ground, petition will be rejected.
Lordship, my point is this, Lordship, both the vehicles are insured with the same insurance company and liability is joint and several, Lordship.
No, it's not.
Because-
Look at the
because-
finding. Please do not make a
Because
submission that is not there.
because the claimant can realize the amount from the any one of the vehicle, Lordship.
Lordship,
Liability is joint and several.
we can make a
So-
case.
So
Lordship, he has to
let
find
it be admitted for after 2 weeks, Lordship. That may kindly fixed. In the meantime, let him provide me the appeal memo. This, Lordship. Let it be listed for admission the next
liability.
2 weeks.
There is no question of joint liability. It's a single clear finding against this vehicle.
Liability is joint and several in
Where is it
every
written?
embassy.
Do you have a
cases,
copy of the
Lordship.
judgment with you?
No. Lordship, then kindly let it fix for after 2 weeks for admission, Lordship. In the meantime, let him provide me the appeal memo, Lordship.
My friend is not prepared to read a copy from the judgment also. Without the. Any submission feel it happen for her, feel it.
Let him list after 2 weeks for admission, Lord, for them. Lordship. That is my humble prayer, Lordship.
Where is your memo of appeal?
Appeal copy. No, but, one more something, the records may be called for, Lordship. Lordship will be able to see what is there in the record. There's nothing, he's trying to make out a case which is not there. There's a clear finding of a tribunal that this vehicle is a.
Heard Mr. R. Goswami, learned counsel for the appellant, also heard Mr. Mr. Agarwala, your initials are Mr.
Yeah,
A.R. Agarwala, learned counsel for the respondent number,
1 to 4, Lordship.
respondent number 1 to 4.
Let it be listed after 2 weeks for admission, Lordship. In the meantime, let him provide
It's
me.
already admitted. No. Lordship, this matter is being admitted today.
We are admitting it.
Yes.
We will fix your IF after 2 weeks.
No, in that case, Lordship, this scan copy of the appeal memo this case record may kindly be called for. I don't have any objection, Lordship. Because we have filed that Baki Jai there, Lordship.
You have already filed.
Yes.
But in the
Then stay.
sort of matter of fact, Lordship, it's not being disclosed to
Lordship,
the honorable court.
again,
He said he will be filing
Lordship,
and trying not.
No.
Lordship, I
You
am
just
also-
now said that you have not yet filed.
No, Lordship, that is my instruction was that they are going to file or they have filed, Lordship, like that only.
So there are two
Now-
things, either they have filed or not filed.
Now,
Yeah.
whether
And
he has
again,
filed.
Lordship, I am recently going one surgery, Lordship. So I am not fit. I have a medical checkup today,
But
Lordship.
that doesn't.
Recently, gallbladder operation, major surgery was there. Lordship.
Okay, we are allowing your
weeks time,
friend
Lordship.
2 weeks time, but we are staying the execution for 2 weeks.
Lordship, for admission, Lordship, because in the meantime, let me study the appeal memo, Lordship.
No. We are fixing the IF after 2 weeks.
For next week, Lordship. Everything.
No,
every
we are,
admission better.
we are staying it because you made a submission that first you made a submission that no Bakija is pending.
Yes, Lordship.
Then you said that Bakija you have
No,
filed.
sir, I don't have any clear instruction.
Therefore, I have to
Lordship.
ensure
That's why, Lordship, next week let it be admitted.
only
For
for a week we will stay.
Yes, for admission, let it be listed for next week, Lordship. For admission itself, Lordship. In the meantime, they will provide with the.
No,
copy.
for admission,
Admission is a matter of.
admission is
Please ask someone to stay there. Admission.
Eh,
Admission happens.
in a admission hearing.
Who will
That is my
admit
humble
admission?
prayer, Lordship. Today I have also go for medical checkup now itself.
First time I have someone asking if the.
Heard Mr. R. Goswami.
Not to be admitted.
Also heard Mr. A.R. Agarwala. This appeal is this appeal under section 173 of the Motor Vehicles Act, 1988 has been filed by the appellant insurance company impugning the judgment and award dated 17/11/2017 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro in MSC case number 1654 2015, whereby the appellant was directed to pay a compensation amount of rupees 8,60,000. 8,60,000
Yes, sir.
along with an interest of rupees,
It looks
interest at the rate of
6%.
6% per annum till realization. The appeal is admitted. Stop. Issue notice to the respondent side. Since Mr. A.R. Agarwala has appeared for respondent number 1 to 4, no formal notice need to be issued to respondent number 1 to 4. However, the
Extra copies.
appellant shall provide the requisite numbers of copies of memo of appeal along with the annexures to the learned counsel for the respondent number 1 to 4 during the course of the day. Today you find.
I'll give it.
As regards respondent number 5, 6, 7, and 8 are concerned, the appellant shall take steps for issuance of notice to the said appellants, said respondent by registered post with AD, as well as by usual mode within a period of 7 days from the date of this order, returnable after 4 weeks. This we are fixing as per your request. When do you want?
That after 4 weeks, Lordship,
No,
or 2 weeks,
we are staying.
no, Lordship, stay should not be granted. If deposit is there 50%, because the insurance is company same for the both the vehicles. And in the award portion, it is
we are-
mentioned 50% deposit will not withdraw. Because it is directed, that OP insurance is directed to deposit, that was.
So my friend is submitting even without going through the judgment. It doesn't have the judgment. I mean, it's not making correct submission. That's what I'm worried about.
No,
But
even
then-
if you deposit to the court,
Yes,
if
Lordship.
they don't withdraw,
Yes,
if we
Lordship.
don't allow withdrawal,
Yes, after
Then-
hearing us.
after hearing them, we will decide whether to allow withdrawal or
Yes,
not.
Lordship, that is.
That I.
Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Mr. A. R. Agarwala, learned counsel for respondent number 1 to 4 claimant. This application under Order 41, Rule 5 of the Code of Civil Procedure, 1908, has been filed by the applicant insurance company, praying for staying the execution of the impugned judgment and award dated 17/11/2017, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MEC case number 1654/2015, during the pendency of the connected MAC appeal number 494/2018. Since the respondent number 1 to 4 claimant
R6 and R8 have been struck off.
have appeared the R6 and R8
Yes, they have been struck off on a earlier.
earlier order is there.
Earlier, they struck off on 22/9/2022. And in the delay conversion.
No, in this we are on waiving the notice to them.
Yes.
We have it. This, and since in the considered opinion of this court, respondent number 6, 7, and 8 may not be necessary for
7 is necessary. 6 and 8.
no, 7 for this interlocutory application.
7 is the owner of the vehicle which does not have an insurance.
Okay. 6 and 8 may not be, they,
Here drivers about the vehicle.
No.
I said here,
no, stay petition. Stay petition also 7 is necessary,
7 would be
necessary.
He's the
Okay,
owner, he can't be let off at any.
okay. Stop.
Only they pay.
6 and 8 may not be necessary. The notice to them, those respondents are waived. As regards respondent number 7 is concerned,
7 is already.
the applicant shall take steps for issuance of notice to the said respondents by registered post with AD. After hearing registered post with AD. In the meanwhile, considering the submissions made by learned counsel for the applicant, the execution of the impugned judgment and award award dated 17/11/2017 passed in MSC case number 1654/2015 shall remain stayed till next returnable date, subject to payment of 50% of the awarded amount by the applicant to the registry of this court within a period of 4 weeks from the date of this order, list accordingly.
Percentage amount shall not be discussed.
We'll file IA only, but
That, yeah, no, that is
Yes.
straightforward.
without
The-
leave of this court.
This, if the said amount is deposited by the applicant insurance company, same shall not be disbursed by the registry without
Liberty.
the order of this court.
Lordship, I am one another, Lordship, I am having another item 20, Lordship. In the admission column, Lordship, I have to go for a
20 month.
medical checkup, so.
We are taking it.
It is also admission, I am there.
What is your submission?
This for enhancement, Lordship. So that will make any admit.
Heard Mr. A.R. Agarwala, learned counsel for the, it is admitted or not?
Not admitted, Lordship. It is
A.R.
for admission.
Agarwala, learned counsel for the. Why it was not admitted?
Today, first time it is for
Okay.
admission, Lordship.
Okay.
Delay upon
For-
found on the earlier.
Learned counsel for the applicant, appellant. Also heard Mr. K.K. Bhatta, learned counsel for
One.
respondent number 1. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant claimant, praying for enhancement of the award. Okay, praying for enhancement of the compensation awarded to sole claimant is there, only one
Yes,
claim
Lordship.
to her by the impugned judgment and award dated 28/3/2023 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MSC case number 1490/2019. Issue notice to the opposite parties, issue notice to the respondents and call for the records of MSC case number 1490/2019. Since Mr. K.K. Bhatto has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, 2 and 3 are concerned, the appellant shall take steps for issuance of notice to the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, this matter your lordship can dispose it of. My lord, the entire awarded amount we have already paid. Now, my lord, substantial question of law, if your lordship look at.
Why this first appeal?
This appeal, my lord, your lordship will find. The
This is not a
50%,
MSC appeal.
Is a MFA, my lord,
Okay,
from
oh,
the Employees Compensation Act.
employees compensation, acha.
Now,
What,
the order passed against us is that 50% penalty should be paid by the insurance company, which is not the correct legal position. But in terms of the act, as well as the appeals court decision is that it is to be paid by the employer only. My lord, that is the only point your lordship is required to be, my lord, to consider.
no.
I'll take your
You
lordship.
have to repeat again.
Beg your pardon.
You are the insurance company.
My lord,
You are the insurance company. And the award was passed in favor of the claimants
right,
for death or injury,
death,
death of their relative.
my lord.
Then what award was passed?
Your lordship may kindly see at page 24, the last page. Last page, I will take your lordship to the last paragraph,
Last pagination is not there.
24, my lord. Pagination is not there, I'm sorry. Pagination-
24 of the memo of appeal.
Memo of appeal, yes.
24.
Yes.
Your lordship, see the last para. If the opposite party number one fails to make payment within 30 days from the date of receipt of the judgment, then this tribunal shall be compelled to initiate legal proceeding as per section 3 of the Revenue Recovery Act. And also shall impose, now we are agreed by that, also shall impose 50% penalty along with 12% interest on the awarded amount from the date of filing of this claim petition. Now, in regard to interest and the principal amount, we have already paid. Now, only, my lord, 50% of penalty. This should be against the owner only. It cannot be against the insurance company.
When this 50% of penalty may be imposed,
My lord, my lord, if there is a delay in making the payment by
Payment.
the owner,
by the owner,
my lord,
who has to make the payment?
the
Insurance
payment
company?
has to be made invariably by the owner first. And as a, my lord, insurer, my lord, we have the liability to reimburse. So therefore, the
Okay.
liability vests on them.
You
they-
directly don't pay to the claimants.
No, it is, first liability is not with us, it vests with the owner. He has to pay it, and if he do not pay in time, my lord, the penalty can be awarded, and the appeals court has made it, clarified it in, my lord, 1997 8 SCC page 1. My lord, I will hand over to your lordship. I'll just read paragraph 14 and paragraph 19. My lord, the relevant part I will take to your lordship. My lord, I'll just read. But similar consequence will not follow in case where additional amount is added to the principal amount of compensation by your penalty to be levied on the employer under circumstances contemplated by section 4A within bracket 3 within bracket small b of the Compensation Act. After issuing show cause notice to the employer concerned, who will have reasonable opportunity to show cause why, on account of some justification on his part for the delay in payment of the compensation amount, he is not liable for this penalty. However, if ultimately the commissioner, after giving reasonable opportunity to the employer to show cause, takes the view that there is no justification for such delay on the part of the insured employer, and because of his unjustified delay and due to his own personal fault, he is held responsible for the delay, then the penalty would get imposed on him. That would add a further sum up to 50% on the principal amount by your penalty to be made good by the defaulting employer. So far as this penalty amount is concerned, it cannot be said that it automatically flows
from the main liability incurred by the insured employer under the Workmen Compensation Act. To that extent, such penalty amount as imposed upon the insured employer would get out of the sweep of the term liability incurred by the insured employer as contemplated by the proviso to section 147(1)(b) of the Motor Vehicle Act, as well as by the terms of the insurance policy found in proviso to B and C to the subsection 1 of section 2 thereof. On the aforesaid interpretation of these two statutory schemes, therefore, the conclusion becomes inevitable that when an employee suffers from a motor accident, injury while on duty on the motor vehicle belonging to the insured employer, the claim for compensation payable under the Compensation Act along with interest thereon, if any, as imposed by the Commissioner in section 3 and 4A, 3A of the Compensation Act will have to be made good by the insurance company jointly with the insured employer. But so far penalty as the amount of penalty imposed, this is our case, my lord. Amount of penalty imposed on the insured employer under contingencies contemplated by section 4A 3B. B is, my lord, penalty is concerned as that is on account of personal fault of the insured, not backed by any justifiable cause. The insurance company cannot be made liable to reimburse that part of the penalty amount imposed on the employer. The latter, because of his own fault and negligence, will have to bear the entire burden of the said penalty amount. Then, my lord, para 19, ultimately their lordship directed. As a result of the aforesaid discussion, it must be held that the question posed for our consideration must be answered partly in the affirmative and partly in the negative. In other words, the insurance company will be liable to meet the claim for compensation along with interest as imposed on the insured employer by the Workmen Commissioner under the Compensation Act on the conjoint operation of section 3 and section 4A subsection 3, that is for interest of the Compensation Act. So far as additional amount of compensation by your penalty imposed on the insured employer by the Workmen Commissioner under section 4A 3B is concerned. However, the insurance company would not remain liable to reimburse the said claim, and that it would be the liability of the insured employer alone. Now, these two paragraphs amply clarify. It is the total responsibility of the employer, and if the employer can satisfy that due to certain inevitable position, the delay occurred, that portion can be condoned. But then, in any case, it cannot be the liability and responsibility of the insurance company. The lordship may see that.
Who is opposite party number 1? At page 24.
I think she is appearing.
No, not in this case, not in this case. Before the
Tribunal.
tribunal, when the order refers to opposite party number 1.
One is insurer, my lord. We are
Insured or insurance company.
We are insurance company.
So you are against this because the direction was to
Against.
opposite party number 1.
Yes, it is against us.
So your submission is that to the extent it directs payment of penalty of 50% by the insurance company, this has to be interfered with.
Well,
Remaining part is okay.
yes, limited, we have already paid the other part. So far, no
Now,
quarrel is there.
50% means 2 lakh something that has to be paid by the
No, I think
insured.
entire liability.
If there is a delay.
This is 5 lakh something along with interest we have already
Paid.
cleared. We have paid. Penalty will be, my lord, the 50% of the principal amount, 2 lakh something.
That will be paid by the insured.
That will be paid by the insured.
Okay. But the insured, whether he has been made party in this case,
Yes, insured is a party. my lord.
you are for
I'm
the
from respondent 1 to 3, lordship.
claimants. Who is Khalilur Rahman?
He's the owner, my lord. He's the insured.
But how his name was struck out? If, because he is the important, he cannot be,
The last. My lord, I don't know, possibly some of my junior has done it without.
because
the
his
legal
name,
position.
because liability will shift to him.
No, in that case, my lord, possibly I'll have to include him party one.
He has to be impleaded.
Exactly. My lord, I was not knowing that he was struck off. He's a necessary party. It's all ignorance of law, my lord.
So what is to be done?
My lord, lordship may be kind enough to allow me to include him to party once again.
Heard Mr. S. Datta, learned counsel for the learned senior counsel, assisted by Mr. S. Datta, learned counsel for the appellants. Also heard Miss
Hey, Akhtar.
J. Akhtar appearing for respondent number 1, 2, and 3. Learned counsel for the 5, 8. Let us see that order. Oh, by last order. You submitted. On last date, your junior S. Datta was there.
I think.
There are one more S. Datta.
My lord, possibly he was knowing the legal position.
क्या लिखा? Learned senior counsel for the appellant has submitted that though on the prayer made by counsel for the respondent, counsel for the appellant, the name of respondent number 5 was strike out from the memo of appeal. However, it appears that the respondent number 1 is a necessary party and he needs to be impleaded again. We recall that portion.
Yes.
Can it be recalled? Is there any bar?
I don't think, my lord.
Then-
That can be recalled. It's totally up to your lordship.
Necessary party. Stop. And he needs to be impleaded as respondent number 4. Stop. In view of the submissions made by learned counsel for the appellant, the order dated 5/8/2024 is modified and modified to the extent that the respondent number 4's name may not be strike out and it is to be shown again as respondent number 4. The registry to do the needful. The appellant shall take steps for issuance of notice to respondent number 4 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
I'm so obliged to your lordship.
You can take back this
Yes.
judgment to crime.
I've spoiled your lordship's valuable time.
No, nothing.
This fact I was not knowing.
I was not aware of this judgment, so I came to know about this. So there is no spoil of
Your
time.
lordship can retain me. Obliged.
Scan copy I say, yes. Scan copy was called for.
Yes, my lord, on 4/12/23.
It has not yet arrived. So reminder has to go.
Lordship, otherwise, in my humble submission, it is not required, Lordship. Only for a small issue, the matter has come before this honorable court. Issue is that, Lordship, whether on the basis of order order of miss case, that is, which is an interim order, the issues which was framed, one of the issue whether it can be striked out. It is a legal issue, Lordship. Perhaps records are not necessary. In the midst of the hearing, if your honorable court is of the view that record will be necessary, then it can be even then called, Lordship. After the break,
But
can
the
be-
court has passed an order for calling for the scan copy.
Lordship,
No, but scan copy has not yet arrived.
Hey, reminder, urgent reminder. notice.
Lordship,
Is there any interim?
yes, they are enjoying interim order and
We
Lordship,
are not enjoying the interim order. It is
actually, Lordship,
on
the
the stay. Stay of
actually-
the further proceeding.
Actually, Lordship, the matter, the man is under suspension for 9 long years. Disciplinary proceeding is continuing for 9 long years also. And Lordship, main case, this is just an offshoot, Lordship. Main case is before the Education Tribunal below. Main case is continuing since 2018. And in the main case, Lordship, that will anyway
Um,
proceed.
Otherwise, it is CRPIO of
Otherwise, it's CRPI.
2023.
That will anyway ultimate fate he will get in the case which is proceeding in the Education Tribunal
We'll take it up at
after
2.
break, Lordship.
At 2.
At 2.
If the records are not necessary, we will proceed with this.
Yes,
hearing.
yes,
At
yes. Much okay.
By collecting the fees from the students. And the principal, professors, staffs were paid by the of the debt fund, collection of fees. There is a rules and regulation of the conduct of the professors. Director on my lord, the defendant, the respondent hearing, Abdul Quddus. He is a practicing advocate of the Dhubri Bar Association. And he was appointed as a part-time lecturer in the Dhubri Law College. He is doing his job as a part-time lecturer in the Dhubri Law College. Thereafter, my lord, he made some misconduct in the college, my lord. Therefore, he was suspended from the post and the inquiry was held. After this suspension, he claimed the subsistence allowance from the college authority. Then as I am suspended from the college, I am entitled to the subsistence allowance. So far subsistence allowance concerned, it is not admissible so far private college is concerned. That is applicable only in the case of government, that is FRN SR 53. Therefore, his petition for prayer for subsistence allowance was not granted. Then he preferred a petition before this honorable court. This honorable court directed the college to release the subsistence allowance is he is entitled to under the law. The college authority says he is not entitled. Then he again moved the Honorable High Court. The High Court then directed the respondent to file a case before the Education Tribunal. He filed a case before the Education Tribunal, and the copy of his petition I have annexed. That is annexure
At page,
annexure A, page 11.
yes.
The respondent has stated the facts of his case, and he was not selected for the vice principal post. He is entitled to that post.
Therefore, the proceeding was initiated. He was suspended from the post. These are his education petition and the prayer. Prayer, your lordship, kindly turn to page 70.
Yes. Mainly he was praying for subsistence allowance.
Allowance rupees 5,28,000. That is his main prayer. In view of the above, your honor will be pleased to, please enough to admit the case. May kindly pass a direction to the principal Dhubri Law College to release the arrears subsistence allowance as per law so and so and so, with 12% interest per annum. That is his case. The college authority filed a written statement stating the full facts that the college is run by the by the collection of fees from the students, and also stated that the GB of the college is the authority and he was not selected and he was doing a disciplinary proceeding was initiated against him and he was suspended. And accordingly, they prayed for dismissal of that case.
Okay. Now, what is the issue here?
My lord,
What order is impugned? Which
no,
order?
I am coming to that.
Okay.
I am coming to that. Now, this is the facts.
The
Facts is it. Thereafter, your lordship come to page 28.
yes, issues are
These are the issues, friend. Is there is any cause of action for filing petition? Whether the suspension of the petitioner is illegal? Whether the petitioner is entitled to get the area subsistence allowance as per law? What relief? And additional issue, whether the petition is maintainable in view of the judgment passed by the WPC. After these issues, my lord, the respondent defendant, the respondent petitioner in that case, filed a petition. That petition I have annexed D page 30.
what is this?
Page 30.
Yes. Praying for release of subsistence allowance.
Yes. Page 31, in view of the above, your honor be pleased enough to consider the serious financial hardship of the petitioner may kindly pass a direction to release the entire area subsistence allowance of rupees 5,28,000. Against this, my lord, the college authority filed written objection. Written objection I have annexed. It is in page 33.
No, this education case was filed for mainly for subsistence allowance only.
That is, I have already read. that is-
Then before disposal of that case, he filed this application for release of subsistence allowance.
Yes.
Okay.
The main relief he was paid for because main relief was 5,28,000 and in the instant petition,
He is seeking that relief only.
that relief.
Okay.
Now we filed an objection. This objection, we have stated that the FR 53 of Assam and Meghalaya government shall not be entitled to the subsistence allowance. And there are some legal impediment in the payment of the subsistence allowance. The learned tribunal, by the order dated 17/1/23, take up the matter and pass the orders. 17/1/23 at page 37.
Yes. What it said?
This is the petition. This is a very long order. I am relying to the only relevant portion of the order. Your lordship can return to page 44.
Yes.
The petition filed by the respondent was numbered as petition number 89 of 2018, dated 25/5/2018. During the pendency of the proceeding, line from 1, 2, 3, 4,
Yes, I got it.
during the pendency of the proceeding on 25/5/18, filed a petition number 89 with a prayer for a direction to the respondent number 1 to release the entire subsistence allowance with effect from this. The petitioner in the said petition stated that the college authority suspended him on so and so on a complaint with with a letter of withdrawal of the college. This letter person, my lord, he moved the Honorable High Court, that petition was considered. Then your lordship can to place 45. Bottom. I have heard the learned counsel for the both sides at length on the petition number 89 of 18 and on perusal of the entire case record, the relevant materials available on record. The original petition dated 4/5/2018, the petitioner prayed for the following release: to pass a direction to the Dhubri Law College to release the area subsistence allowance of 12% per annum, to set aside the suspension order dated 15/6/2015, declaring that the departmental proceeding and its subcommittee has become redundant, and allow the petitioner to join in the service. Therefore, the petitioner filed the petition under order and petition on demand by passing an order directing the Dhubri Law College to release the entire subsistence allowance. Hence, a part of the main prayer is dealt with the petition number 59. This point your lordship kindly know. Hence, the part of the main prayer. His main prayer was to get the subsistence allowance. The part of the main prayer is considered by this order. The learned tribunal heard the matter and passed a very good order holding that the petitioner is not entitled to the subsistence allowance, because the concept of subsistence allowance arises under Rule 53 of the Financial Rules, which the government servants under the suspension shall be entitled to during the period of suspension. And the delinquent is to prove that he is not he is not doing any job during that period. All these are there and discussed. And the page 49, the same paragraph. But as per order dated 16/12/22, I have heard the learned counsel of both the sides, specifically on the following points: whether a part-time employee of a private educational institution is entitled to the subsistence allowance during the period of suspension. This point was dealt with by the learned tribunal, and the learned tribunal, by the order, in course of the hearing, the learned counsel of the petitioner submitted that there is no legal impediment in granting the subsistence allowance, and they submitted that the petitioner is entitled to get the subsistence allowance under the suspension of the general principle of law and equity. The learned counsel for the opposite party, on the other hand, had submitted that the petitioner failed to furnish the non-employment certificate. It is also submitted that the petitioner is a practicing advocate of the Dhubri Bar Association, and he could only furnish a non-employment certificate. The learned counsel appearing on behalf of the Dhubri Law College further submitted that, as per guidelines for the scheme appointed the guest or part-time teachers, the visiting professors, visiting fellow retired teachers, research officer, emeritus dated for 1969 of the UGC part-time teachers may be appointed on the same basis for the temporary teachers on the permanent basis. guest part-time teachers are may not get the benefit of the allowance. Guest or part-time teachers may not get the benefit of the provident fund, pension, gratuity, etc. Normally admissible in the regular teacher of the institution. In the said guidelines, the honorarium of the practicing lawyer to provide a clinical training of LLB students fixed at 1,500 per month. The said guidelines relating to the appointment and allowance as affirmed by the UGC in notification number so and so issued to the Secretary UGC Ministry of Human Resource Development, Delhi. After taking into consideration the materials available on record and the relevant provisions, that a part-time employee of the educational institution is not entitled to get the allowance like permanent employee. In the instant case, the petitioner served a part-time lecturer at Dhubri Law College. He failed to submit the non-employment certificate. And therefore, the Dhubri Law College, even on the equitable and humanitarian ground, did not consider the case of the petitioner fit for granting subsistence allowance. In fact, the petition number 89 dated 25/5/2018. It is a clear that the petitioner's subsistence allowance is not a danger. Rather, he is facing a difficulty for pursuing PhD in conducting the litigation and for the purpose that he need money. Being a practicing advocate, his subsistence allowance is not dependent as a part-time job in the law college. Therefore, I do not find any merit in the petition number 89, and the same is accordingly rejected as the petitioner not entitled to the subsistence. Therefore, the tribunal held that he is not entitled to the subsistence allowance. Thereafter, we filed a petition. Issues I have already submitted before your lordship. Then we filed a petition under Order 14, Rule 5, for striking out the issue number 3. Whether the petitioner is entitled to the area subsistence allowance. Page 52. Whether the petitioner is entitled to get the subsistence allowance as per law. For striking out this issue, because on the petition number 89, the learned tribunal held that a part-time lecturer is an advocate, he is not entitled to the subsistence allowance. Therefore, we prayed for striking out this issue because this issue has already been dealt with in petition number 89. Against this, my lord, the learned, they filed an objection. And the learned tribunal, by the order dated 2/6/23, that is page 57.
Yes.
57 is the type copy. Right petition number 6 so and so on behalf filed by the respondent number so and so with a prayer to strike out issue number 2, which relates to the payment of arrears of rent of subsistence allowance payable to the petitioner Abdul Quddus. I have also perused the written objection filed by the petitioner. Upon perusal of the order dated 17/1/2023, filed in Niche Education case number 2 of 2018, it revealed that the petitioner prayer for granting subsistence allowance was rejected by the state. However, issue number 3 is relating to the arrear subsistence allowance and not the current subsistence allowance. In view of the above, in view of the same, I am of the considered opinion that at this stage of cross-examination of PW, the question of deletion of the issue number 3 may not be allowed. Accordingly, the application filed on behalf of the respondent numbers 10 so and so rejected. Let the matter be cases. Therefore, I am aggrieved by this order because petition number 89 and issue number 3, it's related to the arrear subsistence allowance, not the current subsistence allowance. The learned tribunal in the page 57, he stated, however, issue number 3 is relating to the arrear subsistence allowance and not the correct subsistence allowance. In view of the above, I am of the considered opinion that at this stage, the cross-examination is the case of the respondent was for arrear subsistence allowance. And the tribunal held that the case is for current subsistence allowance. Therefore, this order is bad in law. The learned tribunal in petition number 89 held that he is not entitled to the arrear subsistence allowance. And issue number 3, whether he is entitled to the arrear subsistence allowance. And when we have prayed for striking of that issue, because that issue has already been decided, and the learned tribunal has held that this issue will be treated as a main issue.
Yeah.
Therefore,
But
the
that,
striking of the issue number 3,
but that
rejecting,
issue was decided on an application, that is interlocutory application,
yes,
during the pendency of the proceeding.
yes.
When, where are the issue at, which page issues are? Which is-
Issues are at
28, 28.
28.
Your submission is that as the court has held that he is not entitled to any subsistence allowance.
Yes.
So question of arrear subsistence allowance does
That's
not
not
arise.
And my lord, the page 46,
Page 46.
page 46.
Yes,
Therefore, next paragraph, second paragraph.
yes.
Therefore, the petitioner filed a petition number 89, dated so and so, for passing an order directing the Dhubri law office to release the entire arrear subsistence allowance. Hence, a part of the main prayer is dealt with in petition number 89. Therefore, so far the issue number 3 is concerned, is attained its finality.
No, but issues are to be decided after adducing evidence by both the sides.
My lord, he himself that this, hence the main prayer is dealt with. It is the order of the tribunal, the main prayer is dealt with. That means issue number 3 is dealt with. If issue number 3 is dealt with, then why the issue number 3 will not be struck off when the cross-examination will be plenty? And then whether the one issue can be decided twice in a proceeding by the same court. Because issue number 3,
No, at what stage the proceeding is pending?
no, that proceeding, that part is separate.
No,
the
main
learned-
proceeding.
The
In,
learned,
in the educational tribunal, the petition was filed seeking what relief?
subsistence allowance.
Only subsistence allowance.
Yes.
No other challenge was made.
No.
Order of suspension was also challenged. But
No, no.
main prayer, Lordship, may I submit, Lordship?
No, in view of the above, Your Honor, be please enough to page 17. And may kindly pass a direction to the locals to release the subsistence allowance at 12%. Further, please enough to set aside the illegal suspension order. The main prayer is,
So out
get
of two
the-
prayers, it is one of the main relief.
yes,
Now, this, how the proceedings are conducted in a education tribunal,
it
just
is
like
a suit,
suit, issues are framed, evidence is adduced,
yes.
then arguments. In this case, at what stage the main proceeding was pending?
After it starts from the submission of evidence by the parties.
So whether
Issues
evidence
are
was
fed-
adduced? Evidence was adduced.
The evidence, I think they have not adduced, but
Not started.
evidence not started, but this problem arose when we filed a petition for striking out the issue number 3. Because issue number 3 has been dealt with by the petition number 89.
No, suppose it is not struck off. It is not the order 14 rule 5. This is the
Adding and striking out is dealt with. by
power of the court. Order 14 rule.
Add or it may be the issues may be add or it may be strike out.
Only when lordship it is wrongly framed or wrongly introduced, lordship. Order 14 rule 5.
I'll come to you.
Yes.
Therefore, the learned tribunal, while disposing the petition number 89, is clearly came to a finding that he is not entitled to the substance. And his main prayer in the proceeding is this. And in the impugned order, however, the issue number 3 is relating to the area of subsistence allowance and not the current subsistence. Current subsistence allowance is not a prayer.
No, logic may be not, reasoning may not be right. The tribunal's reasoning may not be right. My query is the issue which should have been decided at the main proceeding. Can it be decided on an interlocutory application?
There is a provision for
Then,
preliminary issue, hearing of preliminary issue. There is no.
then assuming that it is on the court to strike out or not to strike out. Suppose it is not strike out. The issue is not.
Then the findings of petition number 89 will operate as a res judicata.
Those issues will come.
Moreover, this order, the order passed-
Or in view of the findings given against petition number 89, the tribunal may reiterate its earlier finding on the application,
that we do not know. He may not reiterate.
but the necessity is to decide all the issues.
My lord, the preliminary issue, when the point of law is concerned,
But it
the
is,
preliminary issue is always framed in the suit.
but no preliminary issue was framed in this.
It is the
That
tribunal held.
that was the main issue. That
Yes.
whether he is
Hence-
entitled to get
And
subsistence allowance or not.
yes, the tribunal held. Hence, a part of the main prayer is dealt with. That means it is a preliminary issue. If it is a preliminary issue and it is a hard and finally decided, and this order was not challenged by the respondent, therefore this order has attained its finality.
Okay, this submission, when the issue can be strike out,
At any stage of the proceeding.
under what circumstances?
Circumstances may be different.
The order 14, rule 5, clause 2 says it does not give you much. It specifies under what circumstances issues can be struck out. It can be amended.
The court may. at
The
any stage of
scope
the
is
time-
much wider under order 14. Order 14, rule 5, sub-rule 1. The scope is wider. Whether the court can go beyond the mandate of order 14, rule 5, sub-rule 2, that is my query to you.
The court may also at any time before passing a decree, strike out or issue, strike out any of the issues that appear to be wrongly framed or introduced. That is striking out. Adding and striking
Your
out,
prayer is for striking out only.
yes,
So.
because that issue was already dealt with.
But that contemplation is not there in order 14, that before the completion of trial, any issue may be dealt with. Only preliminary issue can be dealt with.
Preliminary issue can be framed, the initial stage
But this is
regarding
not,
the maintainability
but
of
this was not the preliminary issue. This was the main issue.
It was the main issue on their part, and the learned tribunal stated, hence a part of the main prayer is dealt with. It is like a preliminary issue.
Okay.
And my lord, what is this, my lord, so far this prayer is concerned, issue number 3. The evidence of the parties is not required. A preliminary issue can be disposed of at the initial stage when the evidence of the parties are not necessary. Suppose a case of limitation, on the point of limitation, a preliminary issue cannot be framed because the evidence of both the parties is necessary.
What is the procedure prescribed in the, which law operates in education tribunal?
But CPC applied, the procedure.
No,
of the
some,
CPC
there must be some educational tribunal act. There is no such a.
As of now.
Educational tribunal. well,
Under what legal authority this tribunal has been constituted? There
So
must
far-
be some law.
So far, I am told that the procedure prescribed by the CPC is followed by filing a petition, written statement, framing of issues, examination of parties, delivery of certificate.
There is a government notification that your lordship will find at page 38. That
By
is
by virtue of the notification.
notification. But I have failed to collect that notification, page 38, first line. Thereafter, petitioner was advised to approach this tribunal in view of government notification dated 2/6/16. Actually, there has been a judgment of this honorable court. Pursuant to that, a notification was issued and they follow CPC. Procedure adopted is CPC. Some legislation is yet to come, lordship.
No, without any legislation or rules, this education tribunal came into force by virtue of an executive order or what?
There are some,
There has to be some,
District judge is functioning as
no, that I know, that is not my query. My query is what is the law which operates in, by which law this educational tribunal came into force? That is important. You answer my query, we will take it up
on some other day.
on.
Can I point out one thing, lordship? Page
No, I have now. The issue is, in this case, the tribunal on an petition interlocutory application filed by the defendant decided the main issue. Main issue. And you appeared before the tribunal with an application that as the main issue, one out of two main issues, one main issue has already been decided, it needs to be strike out.
Yes.
Tribunal gave a wrong reasoning for that, that I have not decided area subsistence allowance. But actually, when tribunal says that the respondent is not entitled to subsistence allowance, it affects the main issue itself. Now the question is whether could the tribunal have decided the main issue on an interlocutory application if it is not a preliminary issue. This is one query. Second is which law operates in CPC operates, but what is the law by which the tribunals have been brought into force? That is necessary. Yes.
One thing may I point out, Lordship, page 33, their objection to the petition number 89. What they have stated, what is their objection? This is in fact their objection that this prayer cannot be dealt with until the main case is dealt with. Page 33, para number 2. Their
Objection against the
89.
89.
IA.
Yes, that was
Interlocutory.
correct objection.
They state, yes,
That was right objection.
right objection.
But court decided otherwise. The tribunal decided
Reasoning,
Tribunal has given its finding in the
reasoning.
on the main issue itself.
Yes, that is actually the main prayer in the plain and also the prayer in exactly the same prayer. Now, Lordship, whether final relief can be granted at the interim stage, to that effect, I am relying on this judgment, Lordship. 2005, regardless of whatever forum, Lordship, 2005,
No,
9 SCC
no,
733.
It says it cannot be granted.
It cannot be granted.
But
And-
in this case, it has already been granted.
Already been granted. If it is granted, then whether interim order will be binding, my learned senior friend has pointed out res judicata. Whether it will be binding at the final stage,
Okay.
whether it will be binding.
It will not be
It
binding.
will not be binding. It will not be binding.
Now you answer this query. We'll take it up day after tomorrow.
So I have
Day after tomorrow, some other day.
Or
We have to collect the information.
or can we dispose it off on
whatever forum it is, Lordship, whatever law it applies, but this is the jurisprudence, Lordship. This is the jurisprudence. And time and again, Supreme Court has repeatedly discouraged deciding final relief at the interim stage, whatever forum it be, Lordship. And admittedly, it is not admittedly, Lordship, it is clear that it is a preliminary stage, Lordship, because evidence has not started. No witnesses were examined. Documents were not proved. So it is a tentative finding, prima facie finding. A prima facie finding cannot be binding at the final stage, Lordship. It cannot be binding at regardless of whatever forum it may be, Lordship. And here also we see a interim order, stay order is granted, and ultimately writ petition may be dismissed also. So at the final stage, after appreciation of evidence, oral, documentary, everything, the court is free, may have independent, exercises independent mind to take any view, Lordship. And I am ready to face the consequence, Lordship, whatever may be the decision. If this issue is decided at the preliminary stage itself, then matter will become infructuous, Lordship. Matter will become infructuous before the learned court below. It is nothing but man is become 55 years age as on today. The time when he started litigating, he was 46 years.
Novi judgment says that it is not binding in
Lordship.
interim stage something with
Oh.
citation.
2009 5 SCC 694 para 21.
Para?
21. May I read, Lord? Para 21.
Yes.
A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decidendi. An interim order which does not finally and conclusively decide an issue cannot be a precedent. Any reasons assigned in support of such non-final interim order containing prima facie finding are only tentative. Any interim decisions issued on the basis of such prime
Which para you are reading?
21, Lordship.
Yeah.
2009 5 SCC 694. Second judgment I have given, Lordship. Second. 2009 5 SCC.
Yes.
Para 21, Lordship. A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decidendi. An interim order which does not finally and conclusively decide an issue cannot be a precedent. Any reasons assigned in support of such non-final interim order containing prima facie findings are only tentative. Any interim directions issued on the basis of such prima facie findings are temporary arrangements to preserve the status quo till the matter is finally decided, to ensure that the matter does not become either infructuous or a facit accompli before the final hearing. Now, if the subsistence allowance is suppose if it was granted to the employee, it would have been very difficult to have recovered from him, Lordship, until the final issue was decided. So that the matter does not become facit accompli, Lordship, this order was passed. And he is ready to face the consequences. Ultimately, if it goes against him, court may take any view, Lordship. Matter, it is not that everything is gone, Lordship. Court is yet to take the final view. And if your Lordship will have already rightly pointed out by your Lordship, Order 15, Order 14, Rule 5, Subclause 2. The court may also at any time before passing a decree strike out any issues that appear to it to be wrongly framed or introduced. It is not a case where the issue was wrongly framed or introduced. It was rightly framed. It is also not their case, Lordship. It was wrongly framed or introduced. It is only that it was decided. If issues are started deciding at the preliminary stage, Lordship, then it will be a boon for the entire country otherwise, regardless of the technicalities of CPC. This is not a summer issue, Lordship. A detailed procedure laid down under CPC. And even otherwise, it is clearly evident that he filed a petition 89 of 2018. I admitted he ought not to have filed this petition with the same prayer, exactly the same prayer. Lordship will see it is exactly the same prayer. Even the amount, 5,28,000, even the amount specified is also exactly the same. So same prayer cannot be granted at the interim stage.
Then why you filed?
That was my mistake. Ultimately, law will prevail, Lordship.
That was your mistake.
That was a bona fide mistake, Lordship. And ultimately, law should take its course. Law will prevail.
It cannot
This
be a
is what
bona
the-
fide mistake because he is an advocate.
So it was rejected.
He is an advocate practicing in the February bar.
It is not that it was allowed and I am wrongfully enjoying something, Lordship. It was dismissed. It was rejected. Whatever may be the reasoning may not be correct, Lordship. But law is that final relief cannot be granted at the interim stage, and the final relief was not granted in the interim stage. And I honor that law, Lordship. And I honor that law. And Lordship, there is another judgment, Lordship, which is a very short one. This also says, Lordship, ultimate relief cannot be granted at interim stage.
You have given already one judgment on a point.
Another same point, small one, Lordship. Ultimate relief cannot be granted para 2. We are of the
Reference to this.
2005 13 SCC 505. One line, Lordship, I will read para 2. We are of the view that High Court should not have granted the ultimate relief at the interim stage, as the issue seems to be a highly debatable one. So evidence has to be examined, whether he has submitted employment certificate, whether that employment certificate, actually he was employed anywhere, whether he is part-time, full-time, what is his salary, what should be the amount. All these are subject matter of evidence, Lordship. So without examining, it may be a long order. It may be a long order. He has taken his time, learned court below, he has taken his time and written an order. It may be a long order, but ultimately it is an interim order.
No, whether it is the order which has been passed on application number 89. Is it amount to deciding the issue number 3, and whether issue number 3 can be regarded as a preliminary issue because it only dealt with the point of law.
Yes.
That whether a private private college lecturer is entitled to get subsistence allowance on law.
This was, first of all, Lordship, this was not a preliminary issue. Nowhere it was reflected it was preliminary issue. It was part of the main issue. This was in fact his main prayer. What hurdle may come in between, that is there. He has to, the court has to set aside the subsistence order for suspension, and some other consequential order also court may have to set aside. But ultimate relief was subsistence allowance. So it was his main prayer, Lordship. Issue in the issue page 28, Lordship will find.
Your
no-
submission is as it was, no preliminary issue was framed. Therefore, the order passed on 89 could not be treated as
preliminary,
deciding a
preliminary,
point which could have been taken as preliminary issue,
and
and
yes,
thereby decided the issue number 3.
yes, and they are barred by waiver, estoppel,
You
because
will-
The order passed on petition number 89, that was not challenged by the respondent.
because it is
Therefore,
binding.
this order has attained its finality. My learned friend now cannot say it is a preliminary order, preliminary hearing.
Lordship will for once have a look at their objection.
This order was passed on his petition,
Lord-
petition.
Lordship
not
will
my petition.
kindly have a look at their objection. Can they raise this plea now, Lordship? Because they are barred by waiver, estoppel, Lordship. Page 33, their objection, para 2. What they have stated before the court below, and now they are trying to say a completely contradictory thing, Lordship. They say, Lordship, para 2, page 33, their objection, that the petitioner filed the above mentioned case claiming subsistence allowance setting aside suspension order. Next date of the case has been posted on 4/8/18 for written statement. As such, the present petition 89/18 for subsistence allowance before disposal of the case, main petition cannot be entertained. They know the position, Lordship. They are aware of the position. It is only for delaying the main case, Lordship, so that the man attains age of superannuation and ultimately he does not get reinstated. I don't know what will be the fate, Lordship, but it is just nothing but a delaying tactic, Lordship.
Okay, when will you answer my query? That query which I had posed earlier.
Hello?
I posed one query regarding the law which operates on.
Which statement is granted?
No. I'll dispose it off day after tomorrow. Only a notification of law.
Only this,
Which law is applicable?
okay,
I'm fixing
Friday.
it. Friday, I'm fixing it for delivery of orders. I'll dispose of this on that day. On that day, both of you tell me about
I will try my level, Lordship.
how Mr. A.C. Sharma, learned senior counsel, assisted by Mr. G. Bhardwaj, learned counsel for the petitioner, also Mr.
G.J. Sharma, Lordship.
G.J. Sharma, learned counsel for the sole respondent. Hearing concluded, let this case be, though the though the scanned copy of education case number 2 of 2018, which was requisition, has not arrived. However, after going through the contentions raised by both the parties, as well as the materials available on record, this court is of opinion that this written petition may be disposed of even without going through the scanned copy of the education case number 2/2018, as the relevant documents are already annexed along with the revision petition by the petitioner. Stop. Hearing concluded. Let this case be listed for delivery of orders on 16th of August 2020.
Lordship, one thing, Lordship, this order for scan copy was also an interim order, but court can take an independent view regardless of that order also, Lordship. This is
No,
also an example.
I have clarified.
Yes, this is also an example, Lordship.
So
also an
that
example.
order, scan copies order
Same
and the
analogy, Lordship.
petition 89
Same
order, no, these are two different. These are
Same
two
analogy.
different.
We will not start another hearing on
Same
that
analogy.
issue. On Friday, I will deliver.
Okay.
Into ভিতৰত item number. Yes,
Lordship, we have not originally received here, Lordship. We will receive copy from petitioner, Lordship.
what have you not received
Original copy,
of
Lordship.
the petition?
Yes, sir.
You have not supplied the copy.
Lordship, I have, but most probably they have, like, no, I need to give them again, Lordship.
Give it.
I will give.
Okay.
They have only informed me just now, actually.
Service is complete.
Lordship, in the IA, they have already appeared for respondent number 2 and for respondent number 1, I have, in last occasion, I have,
Who is for the petitioner?
I am appearing for the petitioner.
Okay. What?
I am respondent number 2.
No, just a minute. IA has been disposed of or not? This interlocutory application has been disposed of? No.
Lordship, the thing is, Lordship, there is a judicial order, Lordship. Originally, due to some inadvertence, it was filed on some under section 115, which ought not to have been filed. But
So
then
it is treated as an application under 227.
227, I have filed.
So therefore IA becomes infructuous.
That is how. So now this has been registered as CRPIO. And they have appeared for respondent number 2.
No, but IA is still shown as pending.
It has to be some by the registry concerned.
Item number 16.
Lordship.
IA has been dismissed. No, is not shown. Okay. How many respondents are there?
Lordship, only they are appearing because respondent number 1 on the previous occasion, I have striked them out. They are not required.
Respondent number 2.
She is appearing for respondent number 2.
Respondent number 2 is appearing.
Yes.
Respondent number 1's name was struck off
Yes,
on your prayer,
yes. The last occasion.
and you need some time.
Lordship.
Heard Miss Aidas, learned counsel for the petitioner. Also heard Miss, what's your name?
Z. Barua,
G. Barua, learned counsel appearing for
behalf of
the respondent number, appearing on behalf of Mr. S.C. Kayal, learned counsel for respondent number 2, who submits that she has not yet received the copy of petition filed by the petitioner. Hence, they are not ready with the case. The learned counsel for the petitioner undertakes to give a copy of the petition along with the annexures to the counsel for respondent number 2 in a day, within a day,
Lordship.
or today itself.
Lordship, today itself.
Today itself. Let this case be listed again after a week.
Lordship, may I pay for a fixed date, Lordship? Lordship. Can it be on 5th of September, Lordship?
On 5th of September.
Lordship. Deeply obliged, Lordship.
Lordship, this is a case wherein originally claim was filed for injury sustained by the claimant himself. Thereafter, Lordship, the accident occurred in 2015. And 2017, he died. And this is not related to the accident. Death is not related to accident, but tribunal has held that death is due to the accident and assessment has been considered as a death case.
Okay,
That is the point, Lordship.
that
And
you are
in
challenging.
this particular case, Lordship, claimant is entitled for the medical expense, that is rupees 1 lakh.
No.
1,80,908. with
No,
interest.
but that is your plea only, that
That is my plea only, but admittedly, Lordship will find that he died on 17 and accident occurred in 2015. At his admitted position.
maybe because of the accident, that,
There should be some evidence that because of the accident.
no,
he
whether
died.
evidence is not there.
Not, no, for the exam, only claimant has examined himself.
For what this IA has been filed?
I has been filed for stay, Lordship.
Stay. Stay after issue, stay, for stay, you have to pay 50%.
Lordship, we will deposit, Lordship, 1,48,000 with interest. Because otherwise, Lordship, it is withdrawn, we will not get the amount. So 1,48,000 with interest we will deposit, that may be released also. It's medical expense.
And what was the award
Right,
amount?
race portion, Lordship, 14,95,000.
No, you deposit 50%. Out of that, 1,70,000 may be released.
1 lakh, no, Lordship, it may be released, 2 lakhs may be released.
2 lakhs may be released, remaining will stay,
With interest, he will get more, that is why, Lordship, 2 lakh may be released.
remaining will be with the registry. You have to pay 50%,
Deposit 50%,
deposit 50%,
2 lakhs may be released.
2 lakhs may be released,
Released.
remaining will,
Make fixed deposit.
okay. Notice is, case appeal is yet to be admitted.
Lordship, this admission, this come for admission.
Heard Mr. S.K. Goswami, learned counsel for the
2 lakhs.
appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company impugning the judgment and award dated 23/6/2022 passed by the Motor Accident Claims Tribunal number 2 Kamrup Metro at Guwahati in MSC case number 2976/2015, whereby the appellant insurance company was directed to pay a compensation amounting to rupees 14,95,508 to the claimant's respondent. Stop. This appeal is admitted. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondent by registered post with
Respondent
AD
number, Lordship, 4 to 5. 1 to 4 has appeared, Lordship. 1 to 3 has appeared.
1 to 3 have appeared.
Lordship, name has been shown.
No, but there is no order.
The cause list, Lordship, find the name in the cause list.
But is there any wakalat number?
Lordship. And Devnath appeared.
Wakalat number.
Name has been shown in the cause list.
No, on what basis name has been shown?
I do not know, Lordship. Registry has taken his name.
There is no wakalat number. Was there any condonation application?
Lordship. No.
No.
They have acknowledged, Lordship, they have acknowledged the copy of the appeal memo from us also.
But notices are not issued.
1 to 3, Lordship. I will inform, I can also inform, Lordship. Name has been shown in the cause list.
Whose name? This is item number
Item number 17.
17. Name of Mr. N. Devnath
In Devnath.
for respondent number 1. But on what basis? There is nothing on record.
Lordship, that may be the mistake. Otherwise, it is not, name is not reflected. It is entered in the registry in the computer. Thereafter, name has been reflected.
But there has to be something on record. Something on record.
That may be in
Because
record.
registry may commit mistake. We will not
I
go
think-
by
I think Wakalatnama will be there, Lordship.
Wakalatnama Asami. It is. We are issuing notice. You inform them if they appear.
I will inform, Lordship. Personally, they have they received notice from us also. Acknowledging the receipt of
For
1 to 3
notice of this,
claimant. Respondent number 1 to 3.
Learned counsel for the appellant submits that the counsel for respondent number 1, 2, and 3 have already received notice from the counsel for the appellant, and name of respondent number 1 has been also shown in the Wakalatnama. Name of Mr. N. Devnath has been shown as engaged counsel for respondent number 1 in the Wakalatnama. However, the learned counsel for the claimant appellant undertakes to notify the counsel for respondent number 1, 2, and 3. The said prayer is allowed. Issue fresh notice to respondent number 4 and 5 by registered post with AD, as well as by usual mode. The appellant shall take steps for issuance of notice within 7 days from the date of this order, returnable after 4 weeks. Let the case record of MSC case number 2976/2018, 2976/2015 be called for from the concerned tribunal. List accordingly after 4 weeks. This interlocutory application has been filed by the applicant insurance company, praying for staying of the execution of judgment and award dated 23/6/2022, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Guwahati in MSC case number 2976/2015. Learned counsel for the applicant has submitted that the applicant has filed the connected MSC appeal number 165/2024, wherein it has impugned the aforesaid judgment and award on the ground that the tribunal was wrong in coming to the finding that the deceased Ghafarul Hussain, who was the deceased?
Victim. Ghafarul is a victim and claimant is Beauty Begum.
Ghafarul Hussain died as a result of the accident involved in this case, as he died after
on 26 to 17, after 2 years.
After
1.5 years.
After more than 1.5 years of the date of accident. Stop.
And claimant has not examined a doctor to prove that he died.
Stop. Learned counsel for the applicant has also submitted that the applicant does not have any objection in claimant getting the medical expenses incurred on the treatment of the deceased, which comes to
1,80,908
1,80,908 plus
interest from the
accrued
rate of filing
interest
application.
thereon. However, stop, the learned counsel for the applicant has also submitted that the applicant insurance company is ready to deposit 50% of the awarded amount, out of which 2 lakhs
50,000. Interest will get also 1,80,000 interest from 2015. 2,50,000 will be released.
out of which 2,50,000 may be released to the claimants. However, the remaining amount should be kept with the registry in the disposal of the connected MSC appeal. Considering the submissions made by learned counsel for the applicant, the notice to the opposite party respondent is waived, and this interlocutory application is disposed of with a direction to the applicant, disposed of by staying the execution of the judgment and award passed in MSC case number 2976/2015 on 23/6/2022 by the Motor Accident Claims Tribunal number 2 till the pendency of the connected MSC appeal number 165/2024, subject to deposit of 50% of the awarded amount.
Before the registry.
Before the registry of this court. Let them appear in file. I am not passing this. Let them appear and file the prayer for.
Lordship, a release, Lordship, it will be better for claimants.
Okay. On such deposit, the registry may release rupees 2,50,000 out of the said deposit to the claimants
On proper identification.
after proper verification. With the above observation, this interlocutory application is disposed of.
Lordship may also record, Lordship, claimant number 1 and 2. Claimant number 1 is the wife, and claimant number 2 is the son, Lordship.
3.
3 is the mother, Lordship, mother-in-law. Because they are the sufferer. If they come, Lordship, they can get the other payment also. Otherwise, they will suffer. That is why claimant number 1 and 2. Lordship.
No, why not 3?
3, Lordship, dependency. 3 will come regarding the dependency is allowed for death of the person, dependency come, then you will get. 3 will get.
Okay, only to 1 and 2.
1 and 2, that will be better, Lordship.
Okay.
For better the claimant, I am submitting.
Claimant number 1 and 2.
Respondent number 1 and 2.
Respondent number 1 and 2, namely Srimati Beauty Begum and Iftakul Hussain Sakya after proper verification.
Obliged.
May please, your lordship. Now, the decision
Item number?
filed with the
Yes.
filed with the insurance company, lordship, mainly on the ground that, lordship, the deceased was a government employee, lordship. He was a nayak in ASR, Assam Special, lordship, this is Assam Special Reserve Force, lordship. He was a nayak, and as per notification, this is
We-
14/9/17, lordship. Yes, lordship.
No. This is a MSC appeal, na?
Yes, lordship, filed by the insurance company, lordship.
Challenging.
On the,
the-
yes,
How much compensation was awarded?
38,82,773, lordship.
We'll admit the appeal. Appeal will be admitted.
Lordship.
Heard Miss M.
M.
Chaudhary, learned counsel for the appellant. Also heard Miss K. Sharma, learned
Respondent number 5
counsel
and
for
6.
respondent number 5 and 6. None appears for respondent number 1 to 4. Stop. this appeal under section 173 of the Motor Vehicles Act, 1988 has been filed by the appellant insurance company impugning the judgment and award dated 22/4/2022 passed by the Motor Accident Claims Tribunal, Dibrugarh in MSC case number 18/2020, whereby the appellant was directed to pay a compensation amount of rupees, how much? 5 lakhs.
38 lakhs, 82,773.
38 lakhs,
38,
82,773.
82,773. Page number 19, Lordship.
38, 82,773, stop. This appeal is admitted, stop. Issue notice to the
Lordship,
respondents.
I have already furnished the memo of appeal, Lordship, to all the respondents, Lordship.
Since,
Names are
since,
also shown in the cause list.
since all the respondents have already been represented in this appeal, no formal notice need to be issued to them. Call for the case record of MAC case number 18/2020 from the concerned tribunal. List after receipt of the case record from the concerned tribunal after 4 weeks.
There is a IA, Lordship.
If there are
1707 of 2024, Lordship.
for
stay of the execution of the judgment dated 22/4/2020, Lordship.
any objection,
No, Your Lordship.
you deposit 50%.
Lordship, as per latest decision of Honorable Supreme Court, Lordship, that no double compensation should be awarded because they have already receiving the full salary, Lordship. The claimant availed the scheme of family compensation scheme, Lordship. Therefore,
Any
already
submission?
receiving. So double benefit should not be given. This is the latest judgment, Lordship.
Your Lordship, I have no objection because respondent number 1 should have supposed to say.
No, you have no objection if the
Yes.
award is stayed.
No, Your Lordship.
Why?
Your Lordship.
No, just I want to know.
No, since he's representing 5 and 6, Lordship.
5 and 6 only.
Oh, you are not the claimant.
No, Lordship.
Therefore, you have no
Yes,
objection.
Lordship.
So that should be the answer.
Check.
Okay. Then let us hear because they have appeared, their
Yes, Lordship.
counsel have appeared
We have already served copy also, Lordship.
regarding deposit part. You
Lordship,
inform,
this is. Lordship, may stay for the time being, Lordship, till returnable date,
No.
then they will appear and pay for, then Lordship may heard the matter, Lordship. Because this is the latest decision I am having, and our High Court judgment is also there, Lordship. The case is fully covered by the scheme, Lordship. Scheme for compassionate family pension, Lordship. The notification dated 14/9/17, it is fully covered, Lordship.
okay, heard Miss M. Chaudhary, learned counsel for the applicant. Also heard Miss K. Sharma, learned counsel appearing for respondent number 5 and 6. Stop. No one has appeared for respondent number 1, 2, and 3. 1, 2, 3, and 4. Stop. This application has been filed for stay of the execution of judgment and decree. Judgment and award dated 22/4/2022 passed by the Motor Accident Claims Tribunal in MAC case number 18/2020. The applicant has filed a connected, you may see appeal number 253/2024, impugning the aforesaid judgment and award.
I have given the annexure 1, page 10, Lordship, the notification.
In the interlocutor application,
No, in the appeal, Lordship, the appeal memo.
no, you issue notice to the 1, 2, 3, 4 to the council. In,
Lordship, their name is shown in the cause list, Lordship.
okay,
Names are shown in the cause list, Lordship. Till returnable date, Lordship, they may appear. They may be granted till returnable date.
you will issue fresh notice. Whether,
Issue, I think they notice, they have already, they known the case.
then where is the question of returnable date? If you are
On
not,
that day, they may appear, Lordship.
if you are not issuing the notice, we will fix it for hearing on, if the notices, you have already served them. You have served the notice to,
Yes, Lordship, wait, they, I have already furnished, they appeared in the condonation petition, Lordship, condonation matter. They appeared and before that. I
no,
have
but
got the-
they may not appear in, condonation matter is a different,
No, again, I have served the copy, Lordship. They have signed it. They have.
serve the copy of this
Yes,
stay
yes,
application.
Yes, memo of appeal and say, Lordship.
Learned counsel, for
Their
the-
names are also shown, Lordship. in the-
learned counsel for the applicant has submitted that the applicant has served the copy of the stay application to the council for respondent number 1, 2, 3, and 4. But names are not shown.
In the cause list, Lordship, names are not.
This is item number?
Item number 18, Lordship. It's shown in the cause.
Yes, yes. And the names are,
Names that support, sir.
but not specified against which only Mr. Miss.
তোমার নামটা কোনটা? Yes, sir. My learned friend is appearing for P. Bora. And the others are Lordship 1, 5 and 6 HK Sharma. You are appearing for HK Sharma. HK Sharma. P. A. Core. A. Core P. Bora. Receipt position. Ajit Kumar. A code is their Lordship. A code is for 1 to 4. Signed in my appeal, Lordship. Yes. While receiving the copy, Lordship.
Okay.
1 to 4.
1 to 4, namely,
A Raspur.
namely Mr. A. Kaur.
Raspur.
Stop.
1 to 4.
In
Then
view-
Lordship,
You again inform them.
Neelam Nayak. Yes.
She also undertakes to
Yes, Lordship.
inform the council regarding next date of hearing of this application.
Lordship.
Let this matter be listed for, let this interlocutory application be listed for hearing after 4 weeks from the, after 4 weeks on a date to be fixed by registry. And in the meanwhile, till the next date, till the next date in interim, considering the averments made by the applicant in its application as well as submissions made by learned counsel for the applicant, the execution of judgment and award dated judgment, execution of impugned judgment and award is hereby stayed till the next date. List accordingly after 4 weeks.
Must oblige, Lordship.
Appeal against the dismissal of this claim, Your Lordship. This claim has been dismissed only for some technical ground, Your Lordship. So I'll take Your Lordship, page number 15.
You are claimant?
Yes, Your Lordship.
Okay. Heard Mr.
Yes, Your Lordship.
S. Roy, learned counsel for the appellant. Also heard Mr.
J. Kolkata.
J. Kolita appearing for
Question number 1. Oriental Institute.
for respondent number 1, insurance company. This appeal under section 173 of the Motor Vehicles Act has been, Motor Vehicles Act 1988 has been filed by the appellant claimant impugning the judgment and award dated 18/2/2022 passed by the member, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro in MEC case number 2229/2018, dismissing the claim petition filed by the applicant, filed by the appellant. Stop. This appeal is admitted. Stop. Call for the records of MEC case number 2229/2018 from the concerned tribunal. Issue notice to the respondents. Since Mr. J. Kalita has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, no. And Mr. S. Rana appears for respondent number 2. No formal notice need to be issued to respondent number 1 and 2. However, the
I'll serve, Your Lordship.
should I have to record it or?
No, Your Lordship, I'll serve him.
Okay. However, the appellant shall take steps for issuance of notice on respondent number 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Much obliged.
My lord, in this case, my lord, your lordship stipulated 3 months time period for examining the evidences. My lord, kindly see page 46.
What is this?
My lord, this is a bail application, my lord. And my lord, earlier, I approached before your lordship, my lord. And your lordship is considering the delay of trial, stipulated 3 months time period to complete the examination of witnesses. However, my lord, till date, 3 months completed, my lord. No witness were examined.
With a scan copy, I say.
Yes, ma'am.
Since when you are detained behind the?
I have been detained, my lord.
Where is the additional public
I
prosecutor?
have been detained since 27/2/2023
27?
to 2023.
How much time?
My
Not
today is
1 year,
year-
6 months.
1 year, 5 months, 17 days.
Wait for some more days.
My lord, my submission, my lord, 3 months time period is over.
It may be over, but it does not entitle you to get bail on. You are on prolonged incarceration.
Yes, my lord, that was observed by your lordship in this order, my lord, page 46.
Then let it come up after the lapse of this 1 year, 6 months, when it gets over.
My lord, it will be, my lord, on this 17, today is 14. It will be completed on 26, 27,
Let it come after.
28 months. Then maybe next time.
My lord,
Yes.
I'm a full of
Okay. Heard Mr. H.R. Chaudhary. Also heard Mr. K. Bashir, learned counsel for the learned additional public prosecutor. Stop.
It will be
Learned
fixed on 27, my lord. the same.
September first week. Learned counsel for the petitioner submits that in spite of a direction by this court to the trial court to complete the trial expeditiously within 3 months of the date of the said order, the trial court has not been able to examine any further witness. Stop.
Lordship, after this honorable court's order, that is on 5/24, Lordship, that is the last order. Thereafter, only two dates, Lordship. One is 12/6/2024 and one is 18/7/2024. On 12/6/2024, learned court below issued bailable warrant of arrest against the PWs because they were not appeared, they were absent. And 18/7/2024, the next date, the PWs.
What is the contraband?
Contraband, my lord, it is 161 gram of tablets. Yeah.
What tablet?
Yaba tablets.
Yaba tablet.
And that is.
What it contains? Tramadol,
Yaba methamphetamine.
methamphetamine.
And my lord, if we go to the merits of the case, it is recovered from a person, other persons.
Not now.
And not on that, my lord.
Not
And,
now. Learned counsel, on the other hand, learned additional public prosecutor submits that after the directions of this court to
on 13/5/20.
proceed with the case expeditiously, only 2 dates have been fixed in the trial, and the trial court has also even issued bailable warrant of arrest against
Against
the
two PWs.
2 of the prosecution witnesses.
Witnesses.
Stop. In view of submissions made by learned counsel for the parties, let this case be listed again on 9th of September. And let a
My lord, third of September, that will be on
third, okay,
3rd of September.
3rd of September. Let also a report be called for from the trial court regarding an up-to-date status of the case as on 31st of August 2024. List accordingly on 3rd of September.
May I please? Well, it is appeal. Well, this appeal has not yet been admitted,
Not yet been admitted
not admitted.
after 10 years.
Yes. Therefore, by this time, some miscases were also filed. I pray that this may be admitted. And the facts is this matter.
No, why it was not admitted? Perhaps no substantial question of law is
No,
there.
substantial question of law we have.
Then why it was not admitted?
There are some petitions.
Notices were
filed-
issued even before framing substantial question of law.
My lord, it was came up before the court for admission. But may I place some facts?
Yes, yes.
So originally the land was owned by one Munshi Fakir.
No, just a minute, just a minute. Before admission notices were issued, okay. Yes, now,
My lord, the one Munshi Fakir was the original owner of the land.
one who?
Munshi Fakir. Munshi Fakir died.
Who died? Munsif?
Munshi Fakir,
Munsif Fakir. Okay.
he died leaving Sakaruddin, Tasrian Nissa and Rubban Bibi. Sakaruddin died in the year 1948, leaving his wife and 4 daughters. And they and he has some
This I will require a short note. A note would be required because there are many parties.
So there, I am coming to this matter. They are the heirs of Sataruddin. They filed a suit against some of the heirs. And their suit, their plaint is in paragraph, page 18.
Page
18, 18. And the prayer,
No, who filed this suit? Ismail Hussain and others.
and the prayer are in page 23.
How many plaintiffs were there?
There are as many as
29.
29.
29 plaintiffs and 28 defendants.
Yes.
These plaintiffs were descendants of
Sataruddin.
Sataruddin,
Heirs of Sataruddin.
heirs of Sataruddin.
Sataruddin died in the year
And
1948.
what is the relationship of Sataruddin with Munshi? Fakir?
Munshi Fakir's son. Sataruddin father was Munshi.
Okay. And the
My point is this, Mother, they are the heirs of Sataruddin. They claim for partition of the land.
what is the suit land?
Mother,
What is this suit land?
suit land. Suit land, there are A, B, C.
How many schedules are there?
A, B, C, 3 schedules. Schedule A, 2 bigha, 5 lesa. Schedule B, 6 bigha, 1 kata, 7 lesa. And Schedule C, 16 bigha, 3 kata, 8 lesa.
Okay. They filed suit for partition.
They filed suit for
Right title also.
no, wait.
Page 9.
Right title interest, page 23. Right title interest of the suit land. Decree may be passed declaring the plaintiffs have right title interest. Decree may be passed the right title interest of 13 bigha in respect of so and so. The registered deed number 577865. Fraudulent. Decree for partition. Necessary order to collect and precept.
Okay.
Well, my point is very limited. In a suit for partition, a suit has to be filed within 12 years from their right to get the partition. That is Article 110.
But it says
110 by a person excluded from the joint family property to enforce a right to share therein 12 years when the exclusion become known to the plaintiff.
Okay.
Therefore, the original Sataruddin died as airship brought on record. Their words filed a suit for partition. Therefore, they had the knowledge that the suit plan was not partition. Therefore, the suit is apparently barred by
No,
limitation.
112 says, 110 says,
112, any suit except
110.
110.
110 says from the date when their
Exclusion become known.
exclusion is known, exclusion.
Yes.
So suppose if they are not excluded, if they are enjoying the suit property, then this limitation will not come.
No, there is a for recovery of possession also they are not in possession.
Okay.
And my lord, my another point is this, my lord. The prayer number D, the registered deed number 577865 to be declared fraudulent and inoperative in the eye of law, and necessary order may be sent to the registering authority to cancel the sale.
Cancellation of
the-
sale deed.
It is a deed of 1965. And they filed the suit in the year 2001. 2001, no? 2007.
2007.
Yes. Therefore, it is a deed of 1965 and they filed a suit in the year 2007. There are almost 50 years. Therefore, when a prayer for cancellation or declaration that the deed is fraudulent, there is a mandatory provision under Order 624 that the plaintiff has to mention each and every date when they have come to know about the fraudulent deed. There is no mention in the plain. In the plain, they have stated. In the plain, they have stated in paragraph page 22. I am reading, my lord. Entered and covered by so and so. Again, from the Sita copy of the suit line obtained by the plaintiff on 31/2006, the plaintiff came to know the registered deed number 5778 of 65 against the mutation of Rahatan Nessa for the first time, but did not inoperative in the eye of. That is, they have came to know only on the get the certified copy of Sita. How it has become fraudulent when who did the act of fraudulent, there is no mention. Only they have stated when he come to get this copy of the Sita, I found the deed number and it is fraudulent. That too after 40 years. Therefore, this also, my lord. Therefore, my lord, my also the learned court below held that the decreed the suit on these two grounds along with the other grounds. And my counterclaim was rejected. I preferred an appeal before the district judge. And the district judge, without framing any point for determination, as required under Order 41, Rule 31, dispose of the appeal in a very peculiar manner. Therefore, on these points, my lord, the appeal may be admitted, my lord.
What would be the substantial question?
My lord, I have formulated some substantial question of law.
No, whether it is barred by Article 1110, whether this plea was taken before first appellate
Yes,
court.
suit is barred by limitation. They was taken.
No,
They was
whe-
taken.
whether this
Because
was,
it is a legal, it is a legal.
no,
provision.
but whether it was taken before first appellate court
In the appeal,
in the appeal,
in the suit we have taken, is barred by time.
but in the first appeal you have not.
It is the duty of the plaintiff to prove that he has come into any right time. It is our case is this, they have not come within time. Because Sataruddin died
No,
1948.
my query is different. My query is if this was the issue before in the
Yes.
suit
Yes, yes,
and you took this plea before the trial court
yes.
and trial court dismissed your counterclaim and decreed the suit of the plaintiff, whether this point was taken up before the first appellate court.
110 has not specifically taken, but it is,
Because this also involves question of fact. Limitation,
no, limitation is a question of law. It is not a question of.
if
The court
facts
will
are,
look into.
if facts are not disputed.
My lord, whether their right over the property was accrued in such and such time, if they have not claimed their right within the time, then their claim is barred by time. Here in this case, they sought for partition and the partition filed after 12 years. Therefore, it is a legal law point.
After 12 years of what?
After 12 years of seeking partition of the land.
No. 110 speaks about exclusion.
110,
110, Article 110 speaks about
by a person of joint family property to enforce the right. Their claim is this.
when,
12 years, when the exclusion become known to them.
when the exclusion become known to them.
They know that it is the family property.
Now, when the exclusion, when
That
the,
is the cause of action. Your lordship can see the cause of action petition. Cause of action for the suit arose on
Okay,
10/4/2003 in the village so and so and so. 31/2006. These are the 2 dates.
now in this case, whether service.
My lord, I have very carefully gone through the plain written statement in this judgment. In my view, these full questions are the pure questions of substantial question of law to be admitted by this court. And if your lordship kindly see the appellate court judgment at page judgment at page
The record of trial court has been called for? No.
Not.
Not yet. And the service of notice is complete on all the respondents.
It is, I am told that it is not yet completed.
Yes, do you have anything to submit? Or
My
will,
case, whole case is that lordship will find.
no, whether now we are confined only to whether these substantial question of law is involved or not.
Based on new plea, it was not raised before the trial court as well past appellate court. That is not permissible. And first question is that they are legal heirs. Here their claim is that they got the land from Sattar Fakir. Sattar Fakir has lordship will find page 9 of the RSL lordship. Sorry, page 20 lordship. The legal heirs from whom they got the land, who are the legal heirs. Page 20 lordship will find paragraph 4. And here is the case. Original owner is the late Munshi Fakir. Munshi Fakir has one son, Sataruddin. Sataruddin's wife's name is Maimunnesa, and he has two daughters. Here is the case, lordships. Maimunnesa mutated her name in whole the land of Dag number 110, whole land. And she sold the land to Rohatunnesa. That is not permissible, lordship. She is not entitled for whole land. The other legal heirs are there. Late Tosarunnesa, late Rupman Bibi. There also. But he purchased by fraudulently sold the land to his one daughter, whereas Sattar has 5 daughters. Your lordship will find page 20. And my learned friend, senior counsel lordship also stated that regarding limitations, we came to know after obtaining the certified copy of the CITA, and they forcefully entered the vacant land. That is page 21, paragraph 6 is my claim. And the learned trial court and appellate court elaborately discussed that mutation cannot confer any right, title, and interest. It is only for paying of land revenue. And their claim is that on the basis of mutation, their mother Maimunnesa's name entered in the land 110, and prior to enter, it was sold 56. That is fraudulent. Since she has no title at all, she can't sold the land. That is the whole case. And new plea, that is the secondary says new plea lawsuit, that is not admissible. Time again, this court and Supreme Court also says lawsuit. In the case of AIN 1966, Supreme Court 1024. Krishna Kushuba Rao, Kundapur, that after him lives the legal heirs, Dattabai. The learned appellate court also discussed on the specific point.
Where is the judgment of the trial court as well as appellate court?
Findings.
Trial court's judgment is that
Appellate court judgment, your lordship
Is
can return
a-
to page 126.
126.
126. The earlier, it starts from page number. It starts from page number 121. And the operative part is at page 126. Decision thereon and the reasons on decision. And my lord, your lordship, see, it is only 1.5 page judgment.
126 is the
Your lord, page 126.
it is appellate court's judgment.
Appellate court judgment, it starts from page 121.
Yes, 121.
And the judgment, results and judgment decision at page 126.
Of the appellate court's judgment.
Appellate court judgment.
Yes. Now, where is the trial court's judgment?
Trial court judgment.
It's 127, memo of appeal up to only
47,
122.
page 47.
Page 47. I have to go through. I have to go. You are opposing framing of.
Since lordships, there is no questions
No,
of
my
law,
lord,
question law.
what I want to say is this.
Case is regarding
Appeal
forbearance.
is the admission of the appeal is between the court and the appellate.
But for that, we
Yes.
have to find out whether substantial questions.
Yes,
were-
therefore I have already submitted full substantial questions.
So this has
As
to.
my humble submission is, these are the substantial question of law which can be admitted for the proper disposal of the second appeal.
Heard Mr. A.C. Sharma, learned senior counsel assisted by Mr. G. Bhardwaj, learned counsel for the appellant. Also heard Mr.
F.U. Barbia.
F.U. Bordmere, learned counsel for respondent
For
number.
respondent numbers. Lordships. The phone number 1 1 2 3 2 6 8 to 11
Respondent number 1, 326, 8 to 11 and 12 to 29. Also heard Mr. K. R.
As well as
Parkeri.
also couldn't be substituted lordship because of death of and 7 and 2A to 2F
7, no, before
2A
that,
to 2F and 7A to 7C
7, 2A to 2F and 7,
A to 7C
7A to 7C,
12A to 12D
12A to 12D,
sorry 12I 12I
12I to 12D. Also heard Mr. K. R. Parkeri, learned counsel appearing for respondent number 24, 25, 27, 28, 29, 13A, 13B, 13C, 13D, 13E, and stop. This appeal under section 100 of the Code of Civil Procedure has been filed by the appellants. Musammat Rahatan Nisa and 7 others. They are the descendant of Munshi Fakir,
Yes, yes. Sataruddin,
these present appellants,
yes.
who are the legal representative of Sataruddin, son of Munshi Fakir.
as well as plenty respondents.
Munshi Fakir, I will mention it later on. Impugning the judgment dated, judgment and decree dated 22/2014 and 4/3/2014 respectively, passed in title appeal number 5/2010 by learned civil judge Borpeta, whereby the appeal preferred by the present appellants was dismissed, and the judgment and decree dated 21/1/2010 cast in title suit number 83/2007 by learned Munsif number 1 Borpeta was affirmed. Stop. The learned senior counsel for the appellant has submitted that one. Where is the plaint?
Page 18.
This is the original plaint
Yes,
or after substitution? No. Who is Ismail
This is-
Hussain?
This is original. Ismail Hussain is the plaintiff, Lordship.
Who is he of what relationship he has with
He is
Fakir
the
Munshi?
legal heirs of
Munshi Fakir?
Munsif
Sataruddin.
Sataruddin. Sataruddin.
Senior counsel for the appellant has submitted that Ismail Hussain and 29 others who were the legal heirs of one
Lordship, page 20, no, Sataruddin, like Tasurunnesa and.
Sataruddin had 3 wives.
No, Lordship, one wife, 2 daughters.
Okay.
Legal heirs of
Okay.
Sataruddin,
Legal heirs of Sataruddin.
Maimunisa wife,
Okay.
daughter
Safatul,
Tasurunnesa,
Khadbanu,
Tasurunnesa.
Khadeja,
So among the
Sarbat-
plaintiffs, there are some son and daughters of the daughters also.
Yes.
Yes.
Legal heirs of
Page 20.
Real heirs of original owner
Munshi Fakir.
Sataruddin.
Original Munshi Fakir.
Munshi Fakir is the original.
Original.
Munshi Fakir is the-
Legal heirs of Munshi Fakir
Descendants.
who filed the title suit against Musammat Rahatan Nisa and 28 others in respect of scheduled land which has been fully described in Schedule A, B, and C of the plaint. Praying for declaration of right title and interest of the plaintiffs over the suit land and for partition of the suit land, recovery of khas possession, as well as for cancellation of sale deed number 577865. Stop. The said suit was contested by the defendants, Musammat Rahatan Nisa and others, by filing written statement. Wherein stop, written statement. After . How many issues were framed?
Issues, my lord. There are some additional issues as well.
After, on the on the basis of pleadings of the parties, the trial court framed 5 issues and and 4 additional issues. Stop. However, after conclusion of the trial by judgment dated 21 January 2010, the trial court decreed the suit of the plaintiffs stop, against the being aggrieved by the said judgment of the trial court. The plaintiffs within bracket, the appellant in this appeal, defendants in this appeal,
No, the defendant preferred appeal before the first appellate court.
And counterclaim dismissed.
Suit decreed and the defendant preferred appeal.
There was a
you filed a
counterclaim
counterclaim also.
Yes,
that was
counterclaim.
dismissed.
Stop. In the along with the written statement, the written statement as well. Along with the written statement, the defendants also filed counterclaim. Then by judgment and order dated, judgment dated 21/1/2010, the suit of the plaintiff was decreed. However, the counterclaim filed by the defendants was dismissed. Being aggrieved by the judgment of the trial court, the defendants preferred an appeal, preferred a title appeal
I block to the
before the court of learned. Where is the title appeal?
Civil Judge Borpeta.
121. Is there a 25?
One,
My memo 121, Lordship. My son is in offense.
121 is the judgment.
Sorry,
Preferred the
117.
title appeal number
5 of 2010.
why it is mentioned as title suit in the judgment. 121 is the judgment of the trial appellate court. Title appeal number 5/2010. So, and by judgment dated 24/2014, the said appeal was dismissed. Now being aggrieved by the aforesaid appeal, the present appellants who were the defendants in the original suit have filed this second appeal before this court. It is pertinent to mention herein that before formulating the substantial question of law in this case, notices were issued to the respondents as as by order dated 9/1/2015, this court deemed it fit to issue notice of admission to the respondent side before admitting the appeal, considering the nature of issue involved in the appeal. Stop. Though in the memo of appeal, the appellants have stated eight substantial questions of law. However, during the hearings under order 41, rule 11 of the CPC, learned senior counsel for the appellant pressed for formulating following substantial question of law in this case, namely within bracket following substantial dash. Number one, whether the suit is barred under Article 110 of the Limitation Act 1963. Number two, whether the plaintiff could make out a case under Order 6, Rule 4 of the Code of Civil Procedure that the sale deed number 5778 of 1965 is fraudulent. Number three, whether the judgment of the lower appellate court is bad in law for not framing point for determination as required under Order 41, Rule 31 of the Code of Civil Procedure. Number four, whether the prayer for cancellation of deed number 5778 slash of 5778 of 1965 is barred by time. Learned senior counsel for the appellants has submitted that the suit for partition, original suit for partition has been filed by the respondent plaintiff before the trial court after the limitation period of 12 years as prescribed in Article 110, and therefore the trial court as well as first appellate court erred in law in not considering the fact that the suit is barred by limitation. He also submits that a question of limitation is a substantial question of law which can be formulated in the second appeal. He also submits that under Order 6, Rule 4 of the Code of Civil Procedure, the plaintiff has to, what is required? What was your submission regarding order 6 rule 4?
But they have stated that they came to know about the sale, about the gift deed in sell deed in the SITA. But they feel that it is a fraudulent. If it is a fraudulent, then where in the plate is this, the deed is fraudulent. If it is a fraudulent, then it is the duty of the plaintiff to meet the section order 6 rule 4. In all cases in which the party or pleading,
Wherein it is required that in cases where the plaintiff, where the party relies on any misrepresentation, fraud, breach of trust, willful default or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid. Such particulars with date and time, if necessary, shall have to be pleaded in the plain by the plaintiff, which was not done in the instant case. Learned senior counsel for the appellant has also submitted that the first appellate court decided the appeal without framing any point for determination. Therefore, the first appellate court also erred in not following the mandate of Order 41, Rule 31 of the Code of Civil Procedure. Learned counsel for the senior counsel for the appellant has also submitted that the sale deed in question, which was cancelled by the judgment of the trial court, was of the year 1965, whereas the suit was filed in the year 2007. And there it is barred by which provision? Barred by?
barred by time, 3 years.
Okay. The limitation is 3 years.
3 years.
Which is the exact article?
54. To cancel, set aside.
Article?
Article 59.
Barred by Article 59 of the Schedule 1 of the Limitation Act 1963. Stop. On the other hand, Mr. F.U. Bordhoya, learned counsel for the respondent, has submitted that the substantial question of law proposed by the appellant side includes an inquiry into question of facts also. And the said questions are not substantial questions of law. It is also submitted that the appellant have not taken the plea of limitation or other questions involved in the proposed substantial question of law before the first appellate court, and they have for the first time raising the issue before this court, and hence same may not be entertained. Any other submission? Mr. Bordhoya.
Regarding this is the first time lordship. Another aspect, trial court, appellate court lordship specifically discussed about the issues. My learned senior friend, Lordship, senior friend says, as per order 41 rule 31
He also submits that there
does
is
not
no
comply,
violation of
but he complied the applicable.
Order 41, Rule 31 of the Code of Civil Procedure, as though not separate point for determination was framed. However, the First Appellate Court decided and discussed and considered all the issues framed by the trial court.
Issues is not discussed.
That is the
Not issue,
submission.
but specific.
Submission. I will go through it.
Ah,
Hence, he submits that this case does not involve any substantial question of law as proposed by the learned senior counsel, and therefore prays for dismissing the first appeal without admitting the same. Any other submission?
Yes.
Now I have to go through the records. I will not formulate it today. Keep it part on Friday. I will deliver the order. If I find out that the questions proposed by you are substantial question of law, then we will admit the appeal. Otherwise, it will be dismissed. So, Nitya order lipa. Heard Mr. A.C. Sharma, the senior counsel for the appellant, assisted by Mr. G. Bhardwaj. Learned senior counsel assisted by Mr. G. Bhardwaj, learned counsel for the appellant. Also Mr. F.U. Bordmia, learned counsel, F.U. Bordmia, as well as Mr. K.R. Padkiri, learned counsel for the respondents. Let this case be listed, let this appeal be listed on Friday is 16th of August for delivery of order. Oh, no, listed on 16th of August in admission column,
Sorry. One submission, Lordship, regarding limitation part, it is came to know in 2006, that is in the pleadings, and in the aspect of Lordship fraudulent, that is also in pleading. The fraudulent, my learned senior friend relying the order 6, rule 4, that we had no pleadings regarding fraudulent, that is also pleadings are there.
Learned counsel for the respondents have also submitted that the respondent plaintiffs have had complied with the mandate of Order 6, Rule 4 of the Code of Civil Procedure 1908 by specifically mentioning the particulars which are required to be mentioned in the plaint in pursuant to the aforesaid provision of law. I'll go through and find out.
One small consideration. Your Lordship dictated all the respondents, only respondent 1 to 8 came before this court and the appellate court. Only respondent 1 to 8 contest the case, and here is the case.
Okay. Before the trial court.
Trial court as well as this court.
and there are other respondents also. The court was, earlier the court issued notice to them. But some notices has not yet been returned.
Okay, on Friday.
Lordship.
Part is, I have dictated part of the order which I propose to pass on Friday. I will assess your submission and compare it with the material.
No, but if your Lordship is actually want to dispose of this, did the record be called for? Because
No. If it is admitted, I will call for the record. Assuming that it is not at all admitted, then question of calling for record does not arise.
well, that will be helpful for your Lordship. to pass, admit or dismiss, anything? No, that's it.
Now let me go through. If I feel that, because this is an old pending case, if I feel that issues are such that even for framing substantial question of law, records may be required, then I will call for the record. Or in the event of admission of the appeal, records will be called for. Otherwise, it will be disposed of. On Saturday, I don't propose to dispose of the appeal. I propose to pass orders on Order 41, Rule 11, whether to admit or not. If it is admitted, then consequence will follow. If it is not admitted, then no question of calling for record. Putul ভিতৰত দিম। ভিতৰত দিম। By slip পঠাই দিম। Delivery of order নহয়, admission covenant.
Rashid, my senior has some difficulty today. Kindly pass over the matter for the day.
Heard Miss
K Bharali.
K. Bharali.
K Bharali.
K.
K Bharali. K Bharali. K
K. What? Bharali.
Bharali.
Heard Miss K. Bharali, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr.
B Kaushik.
B. Kaushik. Considering the submission, the prayer is allowed. Let this matter be listed after 2 weeks on date to be fixed by registry.
I agree.
None appears for the appellant on call. Let this matter be listed again after a week on a date to be fixed by registry. None appears for appellant on call. Let this matter be listed again after a week on a date to be fixed by registry.
May I please, your lordship? My lord, in this matter, the appellant, the sole appellant has already expired. And it is reflected in order dated 14/5/2024. It was the submission of the learned counsel for the appellant,
Third, Mr.
A. Khan,
A. Khan, learned counsel for the respondent,
respondents, all the private respondents.
all the respondent. None appears for the appellant.
She is present. She is present.
May to the lordship. Unfortunately, my lord, the appellant, he has died. He died.
Now it is abated.
No, my lord.
The appeal is abated.
Abated, my lord, he has no, my lord, I am not pressing the appeal because, my lord, he has no legal heirs. He has not married, no children, no family members, no brother, parents, nobody else.
Also,
So, my
heard
lord,
Miss-
the appeal maybe has.
also heard Miss N. Saikia, learned counsel for the appellant, who submits that appellant has already expired in the year
Expired in 18 April.
when?
This year,
This year,
24.
24.
On 18th April 2024, whether the period of limitation is over.
Yes, yes, your lordship. 90 days is over. And so it was fixed on first of August and it came in orders column.
As 90, learned
After his death.
Miss
the matter came-
Saikia also submits that the appellant does not have any legal representative
Legal heirs.
to or legal heirs who may be substituted in his place. So otherwise also
Really.
90 days have already lapsed since the date of death of the appellant. Hence by this,
I earlier also submitted, my lord.
hence this appeal is abated on the death of the appellant, and on the death of the applicant. Stop.
Lordship, my name doesn't appear in the Wakalatnama. However, my learned friend's name appears, so her name may be recorded.
What is your name? Instead of M. Khan,
Instead of A Khan, it is
A. Khan,
Artal, Miss Artal.
Miss Artalukdar.
Obliged, your Lordship, obliged.
Actually, my lord, immediately after death, my lord, the case came up. I submitted and my lord, that for infractions. But my lord, the final application is that again, I have confirmed he has no legal heirs.
Okay.
What to do? They are lucky enough. They are cousin brothers, they will get automatically. Obliged.
Dota hai disposal. Connected I. In view of disposal of the appeal, this I also dismissed. None appears for the petitioner on call. It appears from record that on last date also, nobody appeared on the for the appellant on call. It appears that the appellant is not interested in pursuing this case. Hence, this case is dismissed for default.
May it please, my lord. Press steps have been taken today. Service may be awaited. My lord.
Heard Mr. N. Chaudhary, learned counsel for the applicant, who submits that fresh steps for issuance of notice on respondent number 1 as directed by this court has been taken today only, and therefore today.
Today,
what
my
is-
lord, they were not in contact with us thereafter. We
Now,
tried to-
what date you have given for appearance?
My lord,
You have to give a date for appearance in the notice. You have taken steps today.
yes, my lord,
The notices were returnable
on today's date.
on today. Notices were issued.
They were
Returnable.
issued today, my lord. That is not reflected in the registry. I have a slip of it.
No, what have you mentioned in the notice? When the respondent should appear? A date has to be given in the notice.
My lord, that has been submitted out subsequent to today's date. If necessary, we will approach the registry and make the necessary changes.
May, today only. Let the notices be returnable after 4 weeks. Notices be returnable on 23 September 2024. Let this case be listed thereafter.
Deeply obliged.
May I take a look? Inadvertently, steps could not be taken with regard to respondent number 1, 2, and 4. I may be allowed a week's time, Your Lordship.
Heard Mr. H. Buragohain, learned counsel for the appellant, who seeks some more time for
Steps to paper publication.
taking steps for paper publication for issuance of notice through paper publication against respondent number 1, 2, and 4. The prayer is allowed. The petitioner may take steps within a week from the date of this order, mentioning in the notice the date of appearance for the aforesaid respondent as 25th of September 2024. Release this matter after the said date.
Deeply obliged. My lord, sorry for the interruption, my lord. My lord, item number 28 that has been abated. There are interim orders in the RSA and also the IA. That
All
may be
vacated.
that may be vacated.
Interim orders. RSA, interim orders, if any,
And in the
Are-
IA 1349, there is
consequent to the 28 minutes, na? Consequent to the abatement of this appeal, interim order, if any, stands vacated.
obliged, Your Honor.
If I may, my lord, the LCR has been received by the section member. The matter can be fixed for hearing. A service is already complete as per order dated 21/8/2017. My lord, as per
Heard
the
Mr.
G Imtiaz.
J. Imtiaz.
G Imtiaz.
G. Imtiaz, learned counsel for the appellant, who submits that the service on the respondents is already complete, which is reflected in order dated
21/8/2017.
21/8/2017. Moreover, from the office note, it also appears that the trial court records as well as first appellate court records have been received. Hence, let this appeal be listed for hearing on a date to be fixed by registry.
Deeply obliged.
Lordship, in this case, LCR has been received. The matter is ready for hearing.
Heard Mr. H. Bura Gohai, learned counsel for the appellant. None has appeared for respondent number 3. The concern record from the case record for concerned motor accident claims tribunal have been received. And this case is ready for hearing. Let this case be listed for hearing by the registry on a date to be fixed by it.
Obliged.
May I please your lordship, IA lordship, 1719 of 19, is for reopen the matrimonial appeal 19 of 2018. There was a mediation lordship, in that mediation, already restored.
1719. 1719, what has happened?
1719 is for reopen the matrimonial appeal lordship.
But I think, Lordship, it was restored on 24/7/24. My friend is saying that, so, yeah, but if Lordship will see the order, I think I have written in my. That's why the Met appeal has come today, Lordship.
On that day, lordship, 1719 was not listed in the course list, so lordship,
2029 was allowed.
yes.
2029. 1719 was restored to file because 1719 was also dismissed for default.
Earlier on, that was restored, earlier occasion,
1719 was also dismissed for default. It was restored.
restored.
Now
Yes.
1719 is for restoration of this
Reopen of matrimonial.
matrimonial appeal. You are objecting?
Lordship, for restoration.
Don't object.
No, I'm objecting, but I'm vehemently objecting, but Lordship, I think
In Harry memorandum of understanding, there was a clause lordship, where it is stated that if any party agreed by the memorandum of understanding before the mediator, he can approve
We can hear this today.
yes.
today, Lordship,
Dispose of it today or let us fix another date.
Another
dispose of
Big-
IA, Lordship can dispose of.
reopen of.
You are objecting the
Yes, I'm objecting, Lordship, but I think Lordship will allow it. I'm vehemently objecting because, I mean, how much time this person has to suffer, Lordship, from 2013, and today, now it is 11 years they are litigating. And
But she is not getting maintenance.
heard Miss R. Boro. R.
Boro Bora.
Boro
B.
Bora. R. Boro Bora. Learned counsel for the applicant. Also her R. D. Majumdar. Learned counsel for the respondent. This interlocutory application has been filed by the applicant applicant Sulak Hannah
Shulakhana Soikia Bharat.
Saikia Bharali for praying for restoration of
Reopen of matter.
reopening means what?
Reopening means matter was earlier settled in mediation lawsuit. Therefore, matter was disposed of.
No, it was dismissed.
No, earlier.
Oh.
No.
Main appeal is disposed of because one settlement was made before the mediator. And there was a clause in that before the mediation lawsuit.
Reopening of the matrimonial appeal, which was earlier disposed of by this court by order dated
Order dated 21/8/2018.
No, on that day, this was disposed of. 21/8 is the memorandum of understanding.
21/8, Lordship, correct, page 11 of this IA, Lordship.
In IA Lordship 1719. Page 11.
Oh, yes. Order dated 21/8/2018. Whereby the stop. Learned counsel for the applicant has submitted that the matrimonial appeal referred by the present applicant
Preferred by the respondent.
referred by the respondent, that is wife, was disposed of by this court on 21/8/2018 in terms of settlement arrived at between the parties during mediation. And in
Why I am objecting, Lordship, simple thing. The appeal was filed by the husband, by my client. And if the appeal is dismissed, how they are aggrieved by that? Why they want to reopen the thing?